ಯಾಕೆ ಇದು ಲೈವ್ ಯಾರು ಕನೆಕ್ಟ್ ಆಗಿಲ್ಲ?
But 2022 matter, my lord, the matters that are stay granted by this honorable court against surfacing matter.
You're all remembering now. Take it someday convenient to the court.
Matters are there.
Yes,
Bank matter, Lordship. Action is on 17th.
take.
Final hearing. Your Lordship, your
Only bank matters.
My lords,
Other matters, please
Bank
make
matter.
mention.
my lords, a bank matter with,
Affected.
I apologize. I filed a vacating application, maybe listed on Monday.
my Lords,
No Monday. It will be listed as per the convenience of the
Much.
your Lordship are directed to rectify the petition, but the pending bank people are not giving the file as it is not reflected in the order sheet. my lord.
Huh? Why? Even for rectification of office objections, for court has to tell
No,
the branch.
there were mistakes in the dates, my lords.
What is this?
Trial court, it is listed on 16th, my lord.
MVC, MFM,
Verify, yes.
MFA and MVC for final hearing.
Is this a claimant's appeal or in the
Insurance appeal.
insurance company's appeal?
Insurance company appeal.
Appeal is filed with insurance company or
Yes,
a
yes.
respondent in claimant's appeal?
Insurance company filed appeal.
Take it.
My lords, there's a correction in the order that was passed. On 2nd of April, Your Honor passed an order directing me to sell the property and deposit the amount. I said 30 days, 20 days is noted in the order. Only for that correction.
Wednesday.
Better.
Madam, memo for withdrawal, 230 criteria. Matter was
So the
bank
court
matter.
is not sitting. Call for that file. Memo for withdrawal. Yes.
Pending GM
1
matter,
o'clock.
Oh, yeah, please.
Yes.
pending GM matter, the respondents have acquired my property without any compensation, my lords. For construction of mobile tower, my lords. That's why any date may be.
My lord,
To take all those memos as per the board, you please. Yes.
Lord, I have filed an application for vacating stay. I appear for IBBI.
What is the bank?
IBBI's order is challenged on the ground that
Just take that. Give it to the court officer. Yes.
The matter become infectious, my lord. Possession notice has been served already.
What is that?
Matter becomes infectious.
Yes.
My lord, 2015 matter. 2015 matter interim order has been extended.
2015,
15 matter, my lord, interim order has been extended, so kindly.
interim order has to be extended,
No,
vacated.
RES. RES.
Yes, list someday. Please call the list.
Page wise adjournment, list number 1, page number 3, serial number 10, 11, page number 4, 2017, page number 5, serial number 18 to 20, list number 2, page number 1, serial number 1, page number 2, 2 to 4.
Serial number 3, my lordship, I am appearing for Shankar Reddy, Practice Council, my lordship, may be taken up next week, my lord, due to personal inconvenience.
Specifically, all these appeals, only in company appeals are listed. I expect that insurance companies won't ask for adjournment. Does this matter next Friday? No
Please,
further
ma'am.
adjournment. MFA of 2013,
Next week, we will not take action.
23 years, 13 years. Yes.
Page number 3, serial number 5 to 8, page number 4, serial number 9 to 9, 10, page number 5, 5 also 10.
Yes.
Page number 7, 11, list number 3, serial number 1, page number 1, serial number 1 and 2, page number 2, serial number 3 to 7, page number 3, 8 to 12, page number 4, serial number 13,
Please call the list.
list 1, for orders matter, serial number 1, Raghunath for petitioner.
This is the matter that I had moved, my lords. The proceedings before the Child Welfare Committee. My lords, there are multiple litigations between the parties. There are
So why
close.
you have moved this memo?
The reason is, my lords, there is an interim order that's in my favor. This honorable court in fact passed an order that the child should not be taken away from my custody. But my lords, child welfare, proceedings of child welfare committee, they cannot be sustainable for the sole reason that the matter is already pending before the family court. Both the father has filed a custody petition, the mother has filed a custody petition. Father's custody
Who
petition,
appears to the respondent?
well, notice has been served on them. They've apparently filed objections also. My lords,
Streets
the
are
act
repealed.
itself says that these proceedings are not maintainable because the child is an adopted child.
Inform him
Please,
before 1:30.
please, correct.
Yes, 2. Memo for withdrawal.
Till number 2, memo for withdrawal.
My lord, the case has been settled outside the court, my lord.
The memo is filed with the seeking withdrawal of the writ petition. It is stated that the dispute was settled outside the court. Accordingly, memo is taken on record and the petition is dismissed as withdrawn.
Till number 3. Till number 3, Sandhya U. Prabhu.
My lord directed me, my lord, to place in statement of objection facts of the case. My lord,
Only for facts,
facts, only 3 paragraphs is important, nothing much. I thought of it.
do that.
Paragraph from, my lord, sorry. Page number 2, paragraph number B, C, and my lord, D. Background of the case.
Paragraph number,
Page number 2, paragraph number B, who availed the loan. Paragraph number C, when it's become NPA. Paragraph number D, my lord, when I issued 13.2. Paragraph number F is, my lord, when I took the position of
Present
property.
petition is
And
filed.
thereafter, my lord, paragraph number O onwards, page number 5. That's all. Hardly.
present writ petition is filed, seeking the following prayer. 1, Mr. Subramanian Naidu, is the borrower. 1, Mr. Subramanian Naidu is the borrower, who is none other than the father of the petitioner. He has borrowed the loan from the respondent bank. As the borrower has failed to pay the, failed to pay the amount, the account was declared as a NPA on 31/3/2015. Thereafter, a notice was issued under section 13(2) of the Surface Act on 28/4/2015. The bank has issued a notice under section 13(4) of the Surface Act on 24/8/2015. And
If, my
symbolic
lord,
portion of the
I took the position on, my lord, 1/3/2019.
symbolic portion of the property was taken on 1/8.
The physical position of property I took on 1/3/2019.
Loans, my lord, there were 2 loans, one by this petitioner, my lord, and one by his father, my lord. Petitioner, my lord, they mention it in second para, my lord.
No, the issue is the loan that is taken by your father, not by you.
There were 2 loans, my lord. One, my lord, Saptagiri Construction, of which, my lord, I am the proprietor.
The subject
And
property is
there
a
were- there were
common
2
collateral
loans.
security. The property belongs to the father. My lord, he is the, my lord, the property stands in the name of father, Mr.
Correct.
Subramanian Naidu.
There were 2 loans.
The bank has taken the symbolic portion of the property. Now, when the bank has tried to take the symbolic portion of the property, and there was a resistance, they have filed criminal miscellaneous 3781 of 2018. And the same was allowed on 1/3/2019.
Then paragraph number O, my lord, page number 5.
The petitioner has also availed another loan, and for that, the very same property is mortgaged to the bank. The bank has put the property to auction. The first auction was on 22/2019, but the auction could not be completed for want of bidders. Then the bank has filed a OA before the DRT, which is numbered as OA 480 of 2019. It's an essay.
Yes, in.
Not bank, they only file.
Hmm?
Everything
I
they only
filed.
file. I am not filed anything. Essay number 390 of, filed by,
Applicant filed securitization.
applicant means
Applicant
they're-
is,
The petitioner herein has filed, petitioner or the father has filed essay,
petitioner only.
petitioner, yes, Mohan.
Petitioner only.
two
Petitioner.
filed.
petitioner.
The petitioner has filed essay number 480 of 2019 before the DRT that came to be dismissed on 30/9/2019 as the auction could not be conducted. Again, the respondent bank issued the sale notice for the second time on 24/9/2019 by reducing the reserve price of rupees 85 lakhs, but the said auction also failed. Finally, the subject property was sold by e-auction on 27/11/2019 to the highest bidder, one Hirachand H. Jain, for an amount of rupees 87 lakh.
ಅದು ಅಲ್ಲ. Lord, paragraph number O onwards, that sale also withdrew.
Huh?
Paragraph number O onwards, my lord, relevant. That sale also, my lord, got cancelled. Paragraph number O, my lord, again I put the property for auction. The respondent has again proceeded with another sale notice on, my lord, 6/5/2022.
Petitioner filed an application under section 17 of the Act by filing essay number 360 of 2019 against a sale notice dated 12/11/2019. And the same was allowed by an order dated 22/1/2020 on the ground of non-compliance of Rule 91 of the rules. However, liberty was given to the respondent to take fresh measures. Another sale notice those two are pending, this 23897 and
Later it got disposed of. It got
All
disposed of.
disposed, ma'am. There's nothing.
Disposed date also I mentioned, my lord. Dismissed as.
then what
non-first-
happened to that? This sale is set aside.
That sale is got set aside. Subsequently,
Set aside. The
O,
respondent
paragraph
has,
number 4,
proceeded with another sale
Sale.
notice dated 6/5/2022.
please, my lord, that is got finalized.
Fixing the date of sale on 30/5/2022 with reserve price of rupees 1 crore 1 lakh. After due compliance of all rules, the property has been sold and said certificate is issued. The petitioner has filed WP number 16155 of 2023 and directed the bank to return the balance amount to the petitioners of the sale proceeds of sale notice dated 6/5/2022. And the court had directed the respondent bank to return the amount along with the interest at bank rate.
The outstanding then was 44 lakhs.
WP number pursuant to the order in WP number 16155 of 2023. The bank has asked the parties to collect all the relevant documents stating the details of charges for which subsequent bills are available. It is stated that it is a case that the petition sister has already taken her share of DD and has collected the copy of the relevant bills which were charged on 17/8/2024. The petition has come up before this court seeking the following prayer. It is a grievance of the petitioner that the respondents it is submitted that the property is sold at 1 crore and according to the bank, the expenses that are incurred are how much? Where is that?
My lord, I filed a memo, my lord, kindly see the memo dated. Please take it out. Here.
Where is that?
My lord, ಇದಕ್ಕಿಂತ ಮುಂಚಿನ memo ಇದೆ. One more memo ಇದೆ. 24/2/2026. Before that, one more memo which I,
23/11/24.
please, my lord. ಇಲ್ಲಿದೆ memo.
23/11/22.
The bank has stated that
ಇಲ್ಲಿದೆ memo.
the bank has kept the demand draft ready for rupees 20 lakhs, 4,732 each, along with the calculation sheet wherein it is stated that the bank has incurred expenses of 62 lakhs,
62 lakhs to 2,104.
92,104.17. And the interest is at rupees 2.75% on the, there's a interest at 2.75%. The petition sister, to the petition sister, a demand a draft for an amount of rupees 20 lakhs 4,737 is already handed over in the year 2004. And for the petitioner, a demand draft is ready for 20 lakhs 4,737. Then counsel for the petitioner submits that. On what basis? When the matter came up on the earlier occasion, a ground is raised. How can they spend the 36, how can they spend 62 lakhs for, towards the expenses? Then this court has directed the petitioner to place the respondent to place before the court what are the expenses as per the same. They placed the memo before the court stating that the property physical possession was taken in the year 2019.
19, my lord.
From 2019 till the property is
And from 2015, my lord, multiple writ petition as well as essay filed.
2015 or 19.
I took the position from 19, but before that I started the, my lord, surface action 2016 onwards.
That surface proceedings were initiated in the year 2015. Physical possession was taken in 2019. And 2009, from 2019 till the property is sold when?
Sold it on, my lord, I'll just tell you that.
2022.
2025, yeah? My lord, 22.
Till the property is sold in
30th April 2022.
Huh? 30th May 2022.
The loan amount what was mentioned due on 30th April 2022 was 44,078.
44 lakh.
That was a sale notice. Not.
When was the position given to the?
My lord, in the year of 2022, maybe, my lord, after 90 days from the
2022, the position was given to the
auction purchase.
auction purchasers. It is submitted that the amounts that are shown as expenses are on the higher side. And further, it is stated that when the amount right from 2022 till now is lying with the bank, and for that amount, the petition is entitled for the interest on a fixed deposit, that is 8 point.
My lord, depends, my lord, if the 6 month, my lord, around 4.75, it depends. It varies, my lord, in FD rate of interest. Here, my lord, with my case, my lord, they are entitled for, my lord, SC rate of interest.
They are entitled for the interest that is chargeable on a fixed deposit. It is submitted that the bank all through was utilizing the money, and they have failed to, and they cannot be, and now they can't offer the interest at 2.7.
2.75, my lord, it's SC rate of interest.
2.5.
75.
2.75.
Land Council has relied on the judgment of the coordinate bench of this court in WP number 16155 of 2023, dated 21st December 2023. He has relied on the which para?
Page 16. Ma'am.
Which para?
Last para. Ink page 16. Inner page 6, my lord. The ink page 16 of the writ petition, my lord. Annexure B. Annexure B, ink page 16.
She has relied on a 16155, said. Writ petition number. She has relied on paragraph number.
Last para, last part.
Paragraph number 4, extract. It is submitted later on when a petition, when a memo is moved for being spoken, when an IA number 1 of 24 is moved, the order is passed by the court. Extract this order, this paragraph and this entire order is passed. It is submitted that in view of the same, the bank has to pay the amount, pay the interest that is as applicable to the fixed deposit.
My lord, the fixed deposit, my lord, if it is more than 400 days, 6.75, 6.25. If it is more than 2 years, my lord, at any, my lord may fix it around 6 or whatever, my lord, I'll leave it to
What is
wisdom.
it?
My lord, 6.25% if
Years and above.
somebody is keeping the money for more than 2 years. That is the FD rate of interest which in Bank of Baroda.
I remember sometime it is 8 point.
No. In fact, I have, my lord, I have taken download from the website itself.
Hmm.
6.25% if they're keeping more than 2 years. It's a website I'm downloading.
The land counsel appearing for the respondent submits that.
No, my case is, my lord, they are entitled only, my lord, in respect of only SB rate of interest. My lord, I'm not
I will
going to
not
consider-
say that you
Please,
said they are entitled for 6.25.
Please, my lord.
Land counsel appearing for the respondent, bank submits that. They have been they have to protect the property, secured property. And they have engaged the services of people. And they're placed before the court, the account to show what are the amounts that are spent by them. Right from 2015 till now, there's been litigation. And the petitioner cannot question the expenditure that's made with the bank. It is submitted that he does not dispute the fact that the amount is lying with them right from 2022 till now. It is stated that the money was always ready with them, but the petitioner has not come forward to receive the money. In fact, the sister has already has taken the money long back in the year 2024.
Please, my lord, in the year of 2024,
Has taken the money in the year 2024.
with interest.
We submitted that petitioner is not entitled for the interest as applicable to a fixed deposit. And they're only entitled for the interest which applies for a saving bank account. Next for having heard the counsels on either side, for a material non-required. After selling the property, whatever is the excess amount, after deducting the expenses, is lying with the bank. The petition has raised the petitioner's argument is with regard to the expenses. How the bank can spend that much of expenses in preserving the property. That aspect, this court is not inclined to go into, as the bank has placed before the court the amounts that are spent by them. No doubt the property, the possession is taken the year 2019 till 2022, till the possession is given to the auction purchaser. They've been protecting the property, and for that they have incurred the expenses. When it comes, and other legal expenses were also included. And this court is not inclined to go into that aspect. Then the next issue is with regard to the interest. The amount of no doubt the amount of the petitioner is lying with the respondent right from 2022. That is after the auction is held. The bank, as per the calculation made by the bank, the petitioner is entitled for only 2.75 interest, considering the fact that the amount is with the bank from the last more than the last 4 years. This court is of the view that the amount shall fetch the interest that is applicable to the fixed deposit. Accordingly, the writ petition is disposed of.
Developing.
Please.
Grateful.
Till number 4,
Lord, the rate of interest,
Fixed deposit, whatever applicable.
please.
Grateful.
till number 4, Shrikant M, petitioner, Vignesh Shetty.
Sorry.
Your Lordship, this is a loan, agricultural loan taken. In the primary security given is the agricultural land. Collateral security was given as revenue land. Your Lordship, while this petition was pending, the writ petition with respect to the agricultural land that was put up in auction came to be settled. We had paid the entire amount. The honorable court noted.
Why are you questioning a sale certificate dated 24/1/2024?
Your Lordship, all of this have been done without notice to the LRs. The co-borrowers no more, that is the fathers no more. He had taken it in the name of husband and wife had taken it. Now the children were not notified. Even when the matter was pending as against the agricultural loan, Your Lordship, they don't bring it to the notice of the High Court. They play a fraud. Might I pass on the order passed by this honorable court closing the entire case? Might I pass it on, court officer? Court officer.
You have copy? Do you have copy? No copy. I'll collect it.
What is this writ petition?
This is with respect to the very same loan. Same loan.
Loan is cleared.
Cleared. And they fraudulently go against the revenue land separately, Your Lordship. I've made even the auction purchaser a party, though of course I am in possession, there is no dispute there, there's no difficulty either. Auction purchaser, the address he gives in his auction, I've taken it on that. Still it says insufficient. The fraud played by the
May I
bank, Your
make only
Lordship.
one request, my lord? I don't have the benefit of the petition. I take it from a friend. That is one. In respect of, my lord, the very same issue, earlier rounds, they came before this honorable court. In fact, all this, I'll place it before this honorable court. Have it tomorrow. And my lord, I'll take a complete instruction. I'll make submissions.
Thursday.
Your Lordship,
Thursday.
Grateful, my lord.
until such time, no
Nothing to
third party
precipitate.
interest.
Already
No,
sales
nothing
certification,
with
Is
me.
there an interim order in this?
No, Your Lordship, since the auction purchase was not being served, all I seek is that he should not in turn sell it to somebody else. That is all I seek.
That we will not grant at this point. We'll hear the matter on Thursday.
Please.
Grateful, my lord. Next.
Bill number 5.
Therefore, petition, my lord. My lords, praise time, my lords. I will make my submissions, my lords. I was not feeling well, my lords. I was suffering from fever
How
and
many times the
infection.
matter will come up?
My lords, last date, my lords, I took time, my lords. Now, my lords, 4 days I was not feeling well, my lords. I could not focus on, my lords, further subsequent
Even
judgment.
after you focus also, you can't do anything. There is
Please,
a
my lord.
Supreme Court judgment.
Please, my lords, I will go through the judgment once again, my lords. I will make an analysis and submit.
Very
Please,
unfortunate,
please,
Mr.
please,
Counsel.
please.
When laws, you don't come prepared to the court and you say that you will take time to
My
read
lords.
a judgment.
Please, my lords. Kind indulgence, my lord. Please, my lords.
List this matter as first matter on Wednesday.
Please, oblige.
Bill number 6.
Beg to appear for the petition.
Yes, primary hearing.
Yes.
But sale notice is challenged.
May we notate?
Agricultural loan, my lord. Coffee land is given as security.
For my learned
My
friend,
lord, coffee land is given as security. My lord, agriculture loan under section 31(1). I of the act, my lord, if interest is created in respect of an agriculture land, my lord, surface act cannot,
It is not an agricultural land.
yes, my lord. Second point, my lord.
just before serving the time of this court, the sale notice what my learned friend has challenged. Under this sale notice, sale had not taken place. After 1 year, by virtue of this sale notice, sale had taken place. I don't know how they call client, his client is aware about that issue or not. In fact, sale certificate is also registered. Both copies I'll hand it over to him. He can challenge it.
Question it all before the DRT, the subsequent, pass on that.
Just passing on the sale notice and sale certificate as well.
The present writ petition is filed, seeking the following prayer. Land counsel appearing for the respondent bank submits that no sale was conducted in pursuant to the notice dated 9/5/2015, which is impugned before this court. It is submitted that thereafter they've issued another sale notice
3/2/2020, last page it is there.
3/2/2026, and auction was conducted
My lord, one submission.
and
was-
the sale certificate was also issued.
OTS proposal was given. During the pendency of that proposal, my lord, they have.
Question there, that we can't decide now. 3/2/2026, the auction was conducted, even the sale certificate is issued in favor of the auction purchaser. In that view of the matter, the petitioner has to question the sale certificate and the other proceedings that have taken subsequent thereto. In that view of the matter, this court is passing the following order. The writ petition is disposed of, giving liberty to the petitioner to avail the appropriate remedy before the DRT. petitioner shall have the benefit of section 14 of the Limitation Act.
Serial number 7, Himantappa Harami.
Appearing upon the petitioner, my lord. My lord, the respondent bank has filed an application before the honorable court below under section 14 of the Regularization Act to take possession of the property. The honorable court below, without hearing the petitioners, allowed the application of the respondent bank and taking over the property of the petitioner.
Why notice should be given to you?
My lord,
Which law says that a notice should be given in section 14
True,
to the borrower?
my lord, it is true.
And
fact.
that apart,
Please, please.
again, is this Jana Small Finance Bank Limited writ petition is not maintainable.
My
Please
lord,
come.
the
The
undertakes to
present
file,
writ petition is filed seeking the following
my lord,
prayer.
undertakes
In
to
the
file
light of the
affidavit,
law
my
laid
lord.
down in Phoenix, in
Undertakes to file affidavit, my lord, if they know.
Vishwabharati so-and-so, the writ petition against so-and-so is not maintainable. The petitioner shall avail the appropriate remedy available to him.
My lord.
Accordingly, writ petition is disposed of. Petitioner shall have the benefit of section 14 of the Surface Act. Next matter.
Serial number 8.
My lord, ready to deposit the amount within 2 months, my lord.
Huh?
We are ready to deposit the amount in 2 months.
No, no, no.
This 1 month, my lord, 1 month at least, my lord.
The writ petition is not maintainable, Mr. Counsel. No argument on that.
My lord, this court had ample powers under Article 226.
No powers.
To entertain.
No powers. Yes.
S. Rajshekar.
I beg to appear for petitioner, my lords, in this case. That's the short
Yes,
point.
Canara Bank who appears?
P. of Purandar, Vignesh Shetty. S. Sandeep.
So-and-so takes notice on behalf of Canara Bank, saw the papers on him.
And sir,
Is this matter on Thursday?
Please, please.
Yes.
Serial number 9. Vignesh Shetty.
Canara Bank, my lord, before my lords. The same, my lord, KPID and SERFICI, my lord, in fact, we assisted this honorable court.
Yeah, that's already done.
I
Where is
want-
that?
I've already filed my written arguments also.
This is actually, no, it's already dictated. WP, that is the writ petition filed by the bank is dismissed, and WP number that is filed by the borrower, the auction purchaser, the bank is directed to refund the amount of rupees so and so. The amount shall carry interest at 9.15% from the date of sale certificate, that is 30/3/2024 till the date of realization. Accordingly, the writ petition is partly allowed.
Grateful.
Grateful.
Lord, in one clarification, Lord, in fact, I only, my lord, granted a loan, sanctioned a loan.
Your overdraft facility is at 9.14%. That's the reason I said 9.14 specifically.
So I can deduct my money which I paid to him, so that remaining money I can pay to him at least.
What is that?
My lord, my money with, my lord, this for this transaction, I have only sanctioned the loan, so that he's paid hardly, my lord, 1 or 2 crore must be. Is the money from his pocket, remaining money paid by bank only.
Then give back to him.
I'll settle the account, my lords.
Huh?
I'll settle the accounts. With the amount that I'm going to get, I'll settle their accounts. Because
No, no.
now the purpose of the loan itself is.
You're getting that 9.14 interest for the
Kindly,
reason,
kindly.
you're taking the overdraft for paying this to for this purpose.
Kind.
Give his bank money as it is. Give
Kind
his
of.
money.
Some clarification on something, my lord, otherwise there must be one more.
I
repetition.
may be
We'll come
directed to
clarify.
clear that loan account. my lords.
Subject to clearing of loan or something,
Yes,
my lord.
I'll add.
Grateful, deeply obliged.
Serial number 10. Gilmadi in B group. Sunil KN for petitioner. AGA.
Then we will file the objections. Statement objection will be filed.
Okay, you need to file.
Yes, it will, because they
Is
have
that?
another copy.
Give the file. No representation on behalf of the petitioner at the request of learned HCGP. Is this matter on 10/4/2026? What is this matter about?
Lords, this is regarding the illegal detention and handcuffing of the petitioners, my lord. The petitioners were,
To direct the respondent to pay a compensation of rupees 2 lakh each to the petitioner jointly and severally by considering the representation dated 14/7/2019. We'll ask them to consider the representation dated 14/7/2019. It's been pending from 21.
Please.
Let them consider.
Please.
If they pass some order, you will get you will get a cause of action, some relief,
please,
isn't it?
please.
The present petition is filed, seeking the following prayer. The facts of the case are the petitioner, the owner of a hotel complex, in view of the acute shortage of parking space in the KSRTC bus stand, the petitioners have opened a pay and parking utility in the open space behind the hotel complex from the year 2000. The public were utilizing the said parking lot for parking the two-wheelers. As and when the vehicle is parked, token will be issued to the person who has parked the vehicle, showing the vehicle number, date and time of parking. And the person who has parked the vehicle while taking back the vehicle will pay the stipulated parking fee. On 11/6/2008, one person came and parked the TVS Excel two-wheeler at about 3 p.m. But thereafter, nobody has come to retrieve the vehicle. In the month of September 2008, person claiming to be the police constable attached to the Arakere police station, however, not being in the uniform, had come and informed that the vehicle is a stolen vehicle and he would seize it. And the second petitioner had informed him that it has been parked by somebody and parking charges is accrued to rupees 1,000. And after paying the parking charges, the vehicle may be taken. How can anybody say this to the police? It's a stolen vehicle. You say that you ask the police to pay the money and take the vehicle. There was a hot discussion, and thereafter, after said person went away, after some time he came along with 5 police constables, one of them carrying a rifle in jeep, and by using force, handcuffed the second petitioner. What is this culture of handcuffing? In every case, I'm seeing this.
I don't think so. It's a bald allegations. It's a bald allegations. There is no proof.
Everybody will not say that he's handcuffed.
No,
I think police are using this.
in some cases, it is required.
No,
It's not a matter of.
Why this handcuffing in the short time I've seen in so many cases. You had handcuffed the second petitioner and dumped into the police jeep. At that time, one MS Anil Kumar, MK Kempaya, GC Krishna, Gopinath, Ravi Kumar, who were acquainted with the petitioner, accosted the police and wanted to know why they have handcuffed the petitioner and taking him away in the police jeep. On 22/1/2008, a person claiming himself to be V. Gopinath and the owner of the said two-wheeler approached the second petitioner, who was looking after the parking lot, and inquired from him as to what would be the parking charges that has accrued and payable. He was informed that a sum of rupees 1,200 has to be paid, and after ascertaining the same, the said person went away. The second petitioner was taken to the Mandya police station, and after seizing the mobile phone of the second petitioner, he was kept in a locked room. The first petitioner, after coming to know of this incident, went to Mandya West police station and wanted to see his son and to talk with him. However, the police personnel there did not permit the first petitioner to talk with the second petitioner. And on 24/10/2008, the first petitioner got where is what is what is that you are asking?
My lords, for compensation, my lords.
What did they do for handcuffing you? That's for that compensation.
My lords,
And you don't say that, you don't say about any other harassment.
It's about illegal detention and handcuffing.
So where is, according to you, like what is the detention?
My lords, request for a pass.
What did you write? The police personnel, they did not permit the first petitioner to talk with the second petitioner and told the petitioner that he must bring the TVS vehicle. Otherwise, the charge sheet will be filed in the court stating the second petitioner has stolen the vehicle and parked in the parking lot. In view of the threat of prosecution, the first petitioner brought the TVS two-wheeler to Mandya police station and delivered it to the police personnel, and thereafter, the second petitioner was released. And you don't even say when is that thereafter. You don't even say, when is that thereafter? 22, you are taken to the police station, you are immediately, you are thereafter released, you say. But you don't even tell when is that? What is illegal detention?
My lords, request for a passover, my lords.
Huh?
Request for a passover, my lords.
Thereafter, on 24/10/2018, the petitioner got issued a legal notice to the sub-inspector of police, narrating the entire incident. The entire incident was informed to the sub-inspector of police to take necessary action against the concern for illegal handcuffing of the second petitioner, illegal detention and handcuffing of the second petitioner in the police station, and also for recovery of parking charges of ₹1,200. It is a grievance that the representation that is given to the you have given representation to whom?
To the
14/7/2019 representation.
An exert
They have given the representation to the to the first respondent, Home Secretary
Home Secretary.
has given a representation to the Home Secretary, and the said representation is not considered. This writ petition is filed in the year 2021. From the year 2021, the writ petition is pending before this court. In the interest of the petitioner, this court deems it appropriate to direct the first respondent to consider the representation dated 14/7/2019 in accordance with law. Accordingly, this court is passing the following order. The writ petition is disposed of, directing the
Sorry, ma'am. Time and again I have been giving representation.
But
In
what
earlier
is-
occasion,
no,
sorry,
no,
my lord,
even-
sorry for
even-
interrupting.
Even the averments in the writ petition, when you say illegal detention, when you were taken for how much, when you were released, what is the illegal detention? Then your petition itself is silent. What is it they will do? Just say, no, you say handcuffing, then the other thing say illegal detention. As far as handcuffing is said, you said somebody has seen, that's fine. Then illegal detention, when you are detained, when you are released, nothing in the petition.
We'll give one second.
Accordingly, the writ petition is disposed of, directing the first respondent to consider the representation in accordance with law within a period of 4 weeks from the date of receipt of the copy of the order. Accordingly disposed of.
Cell number 11, Sunil Kumar H for petitioner, AGA.
11 also similar, but the representation is given to PM. Page
Should have been
number-
disposed of long back,
Yes.
instead of keeping all this pending.
Annexure A.
Writ of mandamus directing the respondents 1 to 3 to consider the representation of the petitioner dated 28/5/2022. Writ of mandamus directing the first respondent set up a special investigation team to conduct the investigation into the legal acts of extortion by respondent number 3 and 4 against the petitioner. To register an FIR against the incident of extortion and cheating. There is no representation on behalf of the petitioner. This is matter for dismissal on 16th of April.
Cell number 12. Cell number 12. Everyone is okay?
I have not received any
I have
affidavit.
already filed the affidavit, my lords. On
You have
8th,
not received copy.
I am serving the copy. I have already sent it by mail.
You need to go through and make submissions.
The respondent has filed the counsel appearing to the bank has filed the affidavit, and the same is filed in the court,
Yes, my lord.
and the same is served. Look at it. Same is served on the counsel for the petitioner. This is matter on 17th of April.
Interim order.
Yes,
I-
sir.
I will request.
Interim order earlier granted is extended till
This
then.
matter, I am representing respondent number 2, my lord. I have received only petition copy, my lord. Last time I have requested the.
The lead counsel for the petition serve the copy of the writ petition on the counsel appearing for
I have already
respondent number
served.
2.
Only
Serve it.
Already served last
Entire
time.
papers are not served.
They are not
That's what is
served to me
needed.
also. I have
not
collected, I have
served. Even they
applied and I got it, my lord.
These
Then
are
I
all
prepared the affidavit.
common
The
submissions show that
petitioner
they
shall
want to.
serve
all.
the
Process.
the entire copy of the writ petition on the counsel for the respondent. Yes, next.
One request, my lord. Last time there is an order passed by this honorable court that 20 lakh of rupees is paid by this respondent number 4 to me. That I am denying, my lord, because I made cause asked instructions. They have not received any money from
That
the
we will, the
respondents.
next time we'll
That may
see.
be recorded, my lord.
Not now.
Otherwise, it will
Then
be,
we will
it will remain on record, my lord.
Next time we will see. Now I can't record anything. Yes,
The IO may be extended.
it's extended.
Much.
Yes, 14.
Bill number 13,
Yes, sir.
TP Muktana.
13 will be covered by still number 10 order, please, my lord.
Same order.
Please, my lord.
My lord, this is different, my lord. I have, last time only this has been
Today
deleted
there
from
is
the
no time
book.
to hear this.
My lord, in this case, my lord will.
Today there is no time to hear this. I'll hear on some other day.
Please.
Yes, my lord.
The MFA matters to take
Yes, my
up.
lord. Yes,
Please,
my
my
Yes, let's just matter on 28th of April.
Yes, my lord.
Please.
Yes, next.
Bill number 14. Bill number 14,
Please, my lord,
Aishwarya Hegde.
pertains to a tender. But my lord,
Any urgency?
oh, there's an interim order operating. That will-
Interim order earlier granted is extended. Let's just matter. Can it go after vacation? Let's just matter after vacation.
Bill
Yes,
number
15.
15.
Filing withdrawal.
Yeah.
Take that.
Lordship, representing for respondent bank, I may be permitted to file my work. They are certainly.
For the respondent.
Yes.
So in years.
Kavi.
Association, my lord, lordship, undertaking affidavit, filing undertaking.
Have you seen?
I've seen that, Your Lordship. By the time they take, they have sought for 4 weeks' time. By then, one more EMI will become due.
As on today, my lord, there is no EMI is pending. Till today, my lord, I paid.
Whatever is now, as per this, what is it going to do?
He is only
But
seeking
In
to
order to
regularize the account.
regularize the account, now this 1.35 lakhs will be paid. But by the time,
If another, if he fails to pay the remaining, you are always at liberty, isn't it?
Please.
Again, you will initiate the proceedings.
please.
My
I'll do it.
submission may be
Present petition
recorded.
is filed seeking the following prayer. The petitioner has filed an undertaking affidavit before this court stating that an amount of rupees 1,35,000 will be paid within 4 weeks. And on that, the respondent may regularize the account. Considering the undertaking affidavit that is filed. And what is the loan that is taken?
Term loan, housing loan,
Housing loan,
40, for
39 lakh something, yes.
39 lakh. Within 4 weeks. Accordingly, the undertaking affidavit is taken on record. And this court is passing the following order. 1, the petitioner shall pay an amount of rupees 1,35,000 by 10th of May. If the petitioner fails to pay the amount by 10th of May, having filed an undertaking affidavit, this is number 2. After filing an undertaking affidavit before this court, he shall pay costs of rupees 50,000 to the respondent bank.
Lordship, also they may be instructed not to misbehave with the officials, Lordship.
All that is not
Lordship,
the work
They
of
have
the.
One submission, my lord.
repeatedly,
If he is misbehaving, file a criminal complaint against him.
One submission, my lord. As on today, my lord, all the EMI suspect, that may be recorded.
observation
I
may
am
be
not
made.
concerned with all
One
that.
observation may be
No,
made,
no,
Your
no.
Lordship.
Yes, next. Yes, please. Yes, next.
Bill number 17, parted, Ravindra V.S. for petitioner.
Last occasion, he has sought for time to file an objection to the petitioner.
Copy.
But this is a fair, my lord, the shop has been rejected.
That you want to read that, you want to go through the
I will go
objections or,
through.
yes,
I will go.
the respondents have filed their objections. Then comes to the petitioner seeks time. This is matter on 23rd, 22nd of April.
Please,
Look at it if interim order is there extent.
please.
Bill number
Well, at presence of the respondent may be dispensed. It's coming 17.
No, please understand the order. I have not asked him to come.
No.
I have provided if The counter, the objections are not, filed. Why should they come?
He has come to sign, so he is present.
I have not asked, no, there is no dispensation at all. I said if the objections are not filed, the consent shall appear. He has already filed.
Yes.
So there is no appearance, there is no dispensation.
Again.
Yes, next.
Please.
Cell number 18.
Respondent number 1, my lord. My lord, filing
With that-
memo. My lord, the petitioner is challenging this position notice, my lord. He claims that he is a tenant and over an unregistered tenant lease agreement, he's making a claim. My lord, the date of mortgage is 15/7/2013, my lord. And the date of rental agreement is during 21, my lord. 2/3.
Date is?
My lord,
Date is?
dated 2/3/2021, which is after creation of mortgage, my lord.
The present petition is filed. Seeking the following prayer. The petitioner, it is a case of the petitioner that petitioner is a lessee who is in lawful possession of the first floor of the scheduled property under a valid lease. Valid lease dated 23/20/21, executed with the second and third respondent lessor. The bank has issued the possession notice at 11/2/2022, which is questioned before this court. It is a case of the respondent, the case of the petitioner that petitioner is a lawful lessee and the respondents, without following the procedure, cannot dispossess them. There is no representation on behalf of the petitioner on 9/4/2026, hence the matter is directed to be listed under the caption for dismissal. A writ petition of 2022 has come up before the court on 27/2023, and thereafter it has come up on 9/4/2026. Today also, there is no representation. Next para. When counsel appearing for the respondent bank submits that the property was mortgaged on 15/7/2013. Even as per the petitioner, the rental agreement was dated 2/3/2021. The remand notice was issued on 7/4/2021 and the possession notice was on 11/2/2022. It is submitted that the bank has a first charge over the property and the rental agreement is subsequent to the mortgage deed dated 15/7/2013. Hence, the lessee of the property cannot come before the court and question a possession notice. Next para, having heard the counsels on either side, there's a material non record. Admittedly, the mortgage is dated 15/7/2013 and the rental agreement is 2/3/2021. Petitioner cannot have any grievance against the 13/4 notice that is issued by the bank. In that view of the matter, this court do not find any reasons to interfere with the possession notice issued by the bank. Accordingly, the petition is dismissed.
Published, my lord.
Yes, next none.
19.
Petition.
My lord, for the respondent in this case, my lord, I seek for a passover in this case, my lord.
Why?
My lord, I'm in city court. It just takes 10 minutes for me to appear before the high court, my lord. I've finished my matter. Just 10 minutes, my lord. I'll reach to the high court, my lord.
Up in 10 minutes.
My lord, in 19.1, there was a direction to conduct a survey. I have conducted a survey and the
Let him
report is-
come, we'll take up the matter. I'll take up it.
Please, ma'am. Please, my lord. Much obliged.
20.
My lord, in this case, from yesterday, the matter has been posted today.
What is the writ petition about?
My lord, according to the
And
prayer,
instead of dismissing it for default, we will pass orders on the merits of it.
that's what my lord, my submission, otherwise they will come again
Yes.
for a restoration of the matter. It is,
Which is a respondent, ICICI Bank.
ICICI Bank is the respondent, it itself is not maintainable. Adding to that, my lord, the earlier,
Well, it
as,
is not a nationalized bank.
it is not a nationalized bank.
No,
No, ICICI Bank, Axis Bank, HDFC Bank, Yes Bank are not, are the private banks, federal bank. They are SBI, Bank of Baroda, my lord, the Indian Overseas Bank, Indian Bank are the nationalized bank. ICICI Bank,
ICICI Bank is not.
ICICI Bank is not it is a
The-
private bank.
the
Federal Bank is
petition-
also a private bank.
The writ petition. Which one?
Federal Bank.
HDFC also.
HDFC is also a private bank. Yes Bank is also a private
Was
bank.
under the impression that it's a
No,
nationalized
no,
bank.
no.
The writ petition is filed
This is
against
the fifth
ICICI.
writ petition.
Huh?
Fifth writ petition, fourth writ.
The writ petition is filed against ICICI Bank
Madam,
seeking the
Madam.
following relief. The matter came up before the court on,
all the measures have been challenged before the court.
before this court on 9/4/2026. That is the first time it is coming up after 25.
Yes, fine.
And as there was no representation, the matter was directly be listed for dismissal. This matter, which is filed on 25/11/2025, has come up before the court for the first time, and there was no representation. Today also, there is no representation. When counsel appearing for the bank submits that the petitioner has filed earlier WP number 33014 of 2024, WP number 33030 of 2024, 33031 of 2024, dated 9/24, and the same came to be
Dismissed.
dismissed.
Directed the petitioner to go to the DRT.
19th December 2024 to avail the appropriate remedy before the DRT.
And the sale notice has been challenged in the subsequent.
Thereafter, the another writ petition is filed, that is WP number 15257 of 2025. And by order dated 27th May 2025, the said writ petition is disposed of, giving liberty to the petitioner to avail the appropriate remedy. Now again, the present writ petition is filed.
Challenging the sale notice. Sale has taken place, sale certificate has also been issued.
Questioning the sale notice, it is submitted that the sale has taken place and the sale certificate is issued. This conduct of the petitioner cannot be appreciated in spite of the repeated petitions being dismissed by the court, directing the petitioner to avail the appropriate remedy. Till now, along with this, the petitioner has filed 5 writ petitions. This is nothing but abuse of process of law. Accordingly, the writ petition is dismissed with cost of ₹20,000 to be paid to the Advocates Association, Bangalore Advocates Association, High Court Advocates Association. Yes.
Much of.
List number 2, serial number 1.
Respondent, first case will respond. Kindly recall the order date. My appeal is also filed.
Madam, already order case, your case is separate. Already order agide, madam. First case.
Yes, I filed an IA to recall the order. Recall of the order will be filed after a passing of the order.
Kindly
argue whether that order can be recalled or not. Who appears?
Appellant, madam.
Manjula Devi, you are, then you have to argue.
She is a proxy counsellor.
When do you want then?
Lord, one humble request. Kindly recall the order. Can here to both taken up together and.
I will do it at once. Recalling the order, passing the order, everything. You ask her to come, I'll hear it. Where is she?
Last date also she appeared. She sought for a time.
This is matter next Friday. Yes,
next Friday, please.
Cell number 2. Cell
Yes.
number 2, D. Vijay Kumar. Vasantappa K.
No representation for dismissal next week. Next Friday.
Cell number 3, urgent. Cell number 4,
Yes, Mr. Venkatesh.
A. Venkatesh.
Paid by the insurer, my lord.
Yes.
Only on quantum as well as negligence, my lordship.
On quantum and?
Negligence of the rider of the motorcycle, which came in touch with my insured bus. Negligence is not considered by the learned.
There should be contributory negligence.
Please.
Then what about the quantum? Come to the.
Quantum, as far as quantum is concerned, my lord, this accident occurred on 7/12/2011. The deceased Manjunath Kamath, age about 32 years.
What is the date? Date of accident?
7/12/2011, my lord.
2011.
At 5:30 a.m., my lord.
What is the amount taken?
My lordship, the amount taken by the MACT at page number 7, 10,000 rupees is taken, my lord.
It should have been 6,500.
Please.
Basing on what the court has taken 10,000?
My lord.
Come to the.
Please. Para 10, page 7, my lordship.
Please read.
It is contained that at the time of accident, deceased Manjunath Kamath was running a grocery shop and his income was rupees 15,000 per month. But no document has been produced to show that profession or business of the deceased Manjunath Kamath. But the petitioner produced a copy of syndicate bank account extract relating to the deceased Manjunath Kamath, which marked at P8. The said extract disclosed that the statement of account relating
So
to
every month there is income of 10,000 in that account.
No, it's not regularly. Exhibit P8 may kindly looked into, my lordship. There is no regular income. There is no grocery shop run by the deceased. That is exhibit P8, my lord. Neither he has said he is a salesman in a company, nor any document produced before the learned judge stating that about his income, except bank statement.
Not here, but this is what, only one case is there.
Only one case, my lordship.
You
Only
have
appeal by
exhibit
the
P8?
insurer.
You have exhibit P8 with you?
Please, ma'am.
Please pass on.
My lord, even that kindly come to the marked documents also. What are the documents they have marked?
Every month there is a credit.
There is a credit
18,000,
there.
15,000, 15,000, 18,000, 16,000, 25,000, 10,000. Every month.
True, my lord.
It is more than that also. So that's how we will assess his
No, no,
income.
5,000 is also there.
No, 5,000 is a debit.
Yes, ma'am.
It's a credit.
Yes.
I mean, debited is.
This is only the bank statement. What is the proof of income is not produced before the judge. For running grocery shop also no document is
Not
placed.
take, we're looking at this, we will not take, if not 10,000, we will take some other amount, but not 6,500.
Please,
We'll take
I
9,000.
will leave it to court.
We'll
my
take
lord.
9,000. Now, if you take 9,000, what is the age?
Age is 32 years, my lord.
How much?
32.
32 years.
Yes, my lord.
What is the multiplier?
Multiplier 16, my lord. He is age about 32 is 16, correct. I have calculated, my lordship.
Comes to 3,600. That is 12,600. How many, who are the dependents?
Yeah, 4, my lordship. 3, minor daughter, wife and father.
3.
3, my lord.
Wife
One
and
third.
father.
Wife, minor daughter and father.
3.
3, my lord.
1/4 has to be deducted.
1/3, my lord. 2 to 3, my lordship.
It comes to 3,150 minus 12,600. His income is 9,450 into 12 into, what is the multiplier you said?
16, my lord.
It comes to 18 lakhs 14,400. 9,450 into 12 into 16. 18,000, 18 lakhs 14,400.
Mine divide.
Huh?
That's the amount, my lord. Loss of dependency divided by
So
3.
it is 9,450 is the income into 12
Into 16.
into 16.
1/3 of it to be taken.
I've already taken 1/3.
What is the income assessed by the court, my lord?
9,000 is taken.
9,000.
40% future prospects would come to 3,600.
Yes, my lord.
Then if it comes to 12,600.
9,360 into
12,600. In the, out of it, 1/3 is deducted. Into 1 divided by 3. No, I think I have divided by.
Yes, my lord, that's what
1/3 I
the
have done.
confusion is.
1/4 I have done.
Please.
It comes to 4,200 minus 12,600 It comes to 8,400. 8,400 into
Into
12.
12 into 16, my lord.
It comes to 16 lakhs. Then 3 into 48. 3 into 48. It comes to 1,44,000, 36,000 and that's 14,400 plus 1,44,000 plus 36,000. It's coming to 17 lakhs 94,400. What is granted by the court?
14 lakhs 22,000, my lord.
Court has granted 22 lakhs.
Please,
Let's see, where is it? Where is the table?
please come to page 9 of the judgment, para 14.
Court
my-
has granted 14,22,000.
Yes, my lord.
Now
My
it's
lord,
coming to
even if-
17 lakhs.
There is something error, my lord.
Huh? No, there is no error.
No, some error is there, my lord. That will
No,
not come.
let's see. No,
Please.
we are taking the income at 19,000.
My lord,
9,000.
9,000,
Plus 40% future prospects.
3,600,
Huh?
3,600.
It comes to how much? 12,600.
Yes, my lord.
12,600.
Divided by 3.
Divide into 1. It comes to 4,200.
4,200 into 12 into
8,400 minus 12,600 minus 4,200. It comes to 8,400.
into 12 into
9 to
16.
12 into
16.
16. Is coming to 16 lakhs 12,800. What should happen to your appeal now?
No, it come taken by the learned judges and I said that's what I am before this court, my lord.
So the calculation mistake is there by the judge. So we'll leave it there. If you
Please.
calculate, it comes to this.
Please, my lord.
Please come. Agreed with her. Award passed in MVC number 118 of 20.
Now, one submission, my lord. I will speak to the advocate on record, Mr. Venkatesh. I will come back to the court next week, may take it.
For judgment next week for dictating the orders.
Please, my lord.
Yes.
17-4.
Yes.
Please.
Cell number 5, Krishna Swami.
Yes, where is Krishna Swami?
May I make one submission?
Krishna Swami.
Serial number 2 in the second.
You are not there.
I was
Serial
held up
number
in-
5, there is no representation on behalf of the insurance company. Is this matter for dismissal? Next matter.
Only one submission, not.
His matter, take up
With
his
your lordship's
matter.
kind permission.
Number 5,
2. Take 2.
Please.
my lord, 5.
My lord, I will not be in station next week, my lord.
I'm applying for the respondent 5, my lord.
No, I have posted it for dismissal. What to do?
Dismissal again. Krishna Swami.
Date next week.
Cell number
Yes,
2,
Friday it will
Next
come.
Friday.
17-4, sir.
My lord, I may be permitted to make one submission. Next week, I will not be in station. I'm going to Canada.
No, you argue now. That's
yes,
what I'm
yes.
saying.
Yes, I'm ready. I'm ready.
Give that file. I'm telling about his case.
I am ready.
Yes.
Cell number 2.
And I want you to make your submissions precisely within 5 minutes, Mr. Vijay
Please,
Kumar.
my lord, here, my lord, it is a case of
Sir, Rangegowda.
the accident between, my
You
lord,
are on what ground?
APSRTC bus and,
You are on what ground?
my lord, the ground is, my lord, the rider of the moped came from left side crossroad, suddenly entered the national highway, came and dashed against the front left portion of the bus. Thereby, my lord, he has contributed to the negligence. You should have, while entering the main road, my lord, other to national highway, you should be very carefully entering.
So only you
Therefore,
are
my
on
lord,
contributory negligence?
contribute.
Only that's ground.
Regarding quantum of compensation, my lord,
Case of death or injury?
age according to the ration card and voters list, my lord, his age more than 60 years.
No,
But the
it's
tribunal
a
has taken, my lord,
Case of
only
death or injury? It's a case of death or injury.
death.
Then postmortem report, what it says?
My lord, postmortem report, my lord, actually, there are various dates
No, we will,
there
we
is
will
no
not,
proper.
we will not consider others, only postmortem certificate, what it says about the age.
My lord, my lord, as per voters list, my lord,
No,
is
let's not go into all that. I asked what the postmortem certificate says. Court must have taken that probably. Look at it, what is the age? Huh? What is the age?
it's taken as 48 years, my lord.
As
13
per the
multiplier is
postmortem
applied.
certificate, what is it?
It cannot be because
As
in the
per-
cross examination, we have suggested he is aged more than 60 years. And my lord, kindly see, my lord, I am passing on the voters list also. Is as on this thing, my
No,
lord, it is 59.
there will be so many discrepancies. Ultimately, we
But
have
he
to look
cannot
at
be
the
49 years. 40.
postmortem report.
My lord,
That is,
my lord, even ration card 60 years. We have suggested that he is 60 years. It is, I am not.
Examine the doctor who has given this postmortem
have
saying
not-
that
they have
this
not-
certificate is wrong.
They have not kind see, my lord. I have pointed out.
As you know, these kind of in Aadhaar card and all for the people who are illiterate, there will be several different
My lord,
dates.
we have suggested that he is aged more than 60 years. And moreover, kindly see, my lord.
Yes, I-
First of all, these claimants, my lord, are the major married children. They are not depending upon income of the deceased.
Problem is, Mr. Vijay, please don't skip from one point to the other. Now we are on the point of age. As far as the age is concerned, I heard your submission, but I will take from the postmortem report. That is over. Then what is the next submission?
My lord, both the children are major
Let's
married
see,
children.
let's see, let us see that. Where is the cost title?
Caste title kindly see, my lord. Ashok,
Ashok,
age about
age
28
28 years.
Sorry, wife of late Krishnappa, residing at Sadinahalli. And Srimati Sumitrama, wife of C. Narayan Swami, daughter of late Krishnappa. Both are married sons. They are not depending upon income of the deceased. Therefore, my lord, the compensation, my lord, to that extent I can concede that 2/3 is deducted and only 1/3 is taken. As far as quantum is concerned, my lord, I have no grievance, much grievance. But as far as contributed negligence, my lord, you asked me kindly see. And age factor, my lord, there is an
So,
authenticated
You have no
document.
objection for taking 1/3? Yes.
Loss of dependency, as loss of
Yes.
dependency.
Next, come to the next aspect. Where is the paragraph? Let us read it.
My lord, it is an admitted fact that he came from a left side crossroad and suddenly entered the main road. My lord, it start from para, my lord, 9 of the judgment, my lord.
Please read.
My lord, the petitioner number 1 has filed his affidavit in evidence attributing rash and negligent driving of the driver of KSRC bus number so and so. It is the evidence of PW1 that the deceased by name Krishnappa was proceeding on so and so towards Bangarpeta on 7 p.m. when his motorcycle was proceeding on the road in between Chikkasala and Dimba village gate. It was proceeding on the left side of the road, but slowly by observing all traffic routes. At that time, the driver of APSRC bus number so and so drove in a opposite direction with high speed and in a rash and negligent manner and dashed the motorcycle of the said Krishnappa, and due to the impact, Krishnappa died so and so. But he came from left side crossroad and suddenly entered the main road. Yeah, please, my lord. Due to the impact, sustained the fatal injuries and succumbed to the injuries at the spot. Further, it is evidence that the said accident took place due to the rash and negligent driving of the driver of APSRC bus number so and so. In the cross-examination of PW1, denied the suggestion that accident took place due to the rash and negligent act of the deceased in riding the cycle and not due to the rash and negligent driving of the deceased by name Krishnappa, who was proceeding on his motorcycle number so and so towards Bangarpete, and at 7 p.m. when his motorcycle was proceeding on the road in between Chikkasala Dimba village gate, it was proceeding on the left side of the road slowly and observing all traffic rules and regulations in the opposite direction. My lord, this is totally opposite direction is totally false. My lord, in the cross examination, my lord, we have clearly suggested
We'll
that
complete
he
this.
came from left side.
We'll complete this and we'll go to that.
Complete this, yes, my lord. Left side of the road, and by observing all traffic rules at that time, driver of the APSRC bus number so and so drove it in an opposite direction with high speed in a rash and negligent manner and dashed the motorcycle of the said Krishnappa, and due to the impact, the Krishnappa sustained fatal injuries and succumbed to the injuries at the spot itself. The said accident took place due to the rash and negligent driving of the driver of the so and so. Petitioners have produced a copy of the so and so, so and so, so and so, my lord. True copy so and so, so and so. My lord, there is no discussion about any other thing. Simply documents.
Come to the bold letters where.
Yes,
the
my lord. It is
evidence
true that
discussed.
I was the driver of the APSRC bus bearing number so at the time of accident. Here, the accident in question took place between two vehicles, bus AP 28Z1574 and TVS XL moped, KA04Q 6673. It is true that relating to the said accident, a criminal case number so and so has been registered against me, and subsequently after investigation the case, the said police have filed charge sheet against me to the concerned court at Kolar, making allegations that the said accident took place due to my rash and negligent driving of the driver of the APSRC bus number so and so. The said criminal case is still pending in the said court. At the time of accident, my bus was proceeding from Bangarpete towards Kolara. I have not filed separate written complaint either to the police or to the court alleging that the accident took place due to the negligence of the rider of the TVS XL number so and so. From these materials on record, it is clear that the said accident took place due to the negligence of the driving of the APSRC bus number so and so, and affirmative.
Yes. Give that, give the Panchnama. Now we can understand. Panchnama is into the map. Let's see the sketch.
Bus is on the correct side of the road, my lord. It is on the highway.
Yes.
And
Where the accident had taken place?
my lord, it is in the Kolar, Mulabagal, the place of accident, my lord. Proceeding on road between Chikkasala Dimba village.
Hmm. Hmm.
On Kolar Bangarpet road.
From what you are submitting to the court, basing on what, that he was negligent?
My lord, based on the information given by the driver of the
He
APSRC
didn't
bus.
give any information. He
Like
doesn't
what?
even say in the criminal case that it is a mistake. Let's not go into all that now. Please come.
We have not examined RW1 also, driver.
The petition, the present appeal is filed agreed with or by the present appeal is filed with the insurance company. Your appeal is there?
No, madam.
The
No,
present
madam.
appeal-
Cross appeal is there,
Our
madam.
objection is barred by limitation.
Sorry,
It is
madam.
filed recently.
Cross appeal is there, madam.
When is it filed?
Recently, my lord.
22, in the year 22.
Yes.
Accident is in 2017. After receiving the money which we have deposited, 50% they are filed.
Is there any bar
No,
on
no,
that?
no, one submission, my lord. No amount is deposited but not received, my lord. After came to know that they have filed the appeal before this court, when we voluntarily appears and filed wakalat, my lord.
When did you file your wakalat?
In the year 2022, my lord.
Appeal is
I have
filed
no
when?
knowledge about after verifying
Cross
this.
appeal is filed when?
22. Filed by one of the claimant, my lord.
That's what.
Only
you
one of
filed
the,
it in
that two
22.
daughter, the two elder sister,
22 in the year.
elder sister.
14, 12, 22, my lord.
Yes. So please come. What is the, how much is the income taken by the court?
4,500, my lord.
Which year is the accident?
2012, my lord.
According to you, what is the income of the deceased?
He is an agriculturist, my lord.
You must have stated something in your claim petition.
25,000.
First of all, no dependency at all.
Daughter of the deceased, so
25,000.
deceased was earning 25,000. This accident is in 2012.
12, my lord.
2012. What is the age?
48 years.
45.
48, my lord.
59 to 60
As per the
years.
postmortem report, how much was taken?
48, my lord.
48?
48.
Kindly see the age of the claimants, my lord. How can there be within such a short distance, the age of the father and the children, my lord? 3 daughters. In the cross examination, we have suggested is 60 years.
Postmortem report, the age is 45.
Yes, my lord.
That is
Court has
totally
taken-
wrong.
Court has considered 48 years.
Why?
Based on the evidence of the PW1,
Yes,
son
we'll
of
take-
the deceased, my
We'll
lord.
take 45. Plus 25%.
My lord, he admits, it is true that in the petition I have shown my age of the father is 48 years. He has shown the age as 48 years.
So Vijay Kumar, you please understand what is the law that you please tell the court.
My lord, PM report cannot be.
It is. It is.
Only for that. Before that, my lord, at an undisputed point of time, voters list shows 59 years. 59 years. And the first claimant also died. Only now two daughters, they are married, residing separately, along with their family members, and not depending on income.
They're only concerned as on that day, not what has happened.
Even on that day also they are married.
What has transpired thereafter, we are not concerned.
Right, even that day.
That I will consider. She is a widowed daughter.
Alla widow anteniಲ್ಲ.
Wife of late so and so. Look at
My
it.
lord.
Look at the cost title.
ಅಲ್ಲ that may be mistake. ಏಕೆ ಅಂತ ಹೇಳಿದ್ರೆ ಅಶೋಕ, kindly see the cost title of the first petitioner, my lord. My lord, that is a mistake. How can he be daughter, wife of Ashoka? Ashoka is wife of Krishnappa. That is a mistake committed.
What is the name of the deceased?
Krishnappa. Krishnappa.
That is the son of late Krishnappa.
Wife of Antide. That is a
Then,
mistake
the
even
other-
there
then
also.
the next one is?
Typographical mistake. my lord.
No, then the next one is wife of C. Narayan Swami. Now, who is the claimant now?
Claimants only the daughters, major daughters.
What happened to the son?
My lord,
Died. He also
during
died.
the pendency of this appeal, Ashoka claimant number 1 is died, my lord.
What about his children?
His children's already brought on record, my lord. They have
I
filed
am
the application.
representing, I am representing my lord LRs of R1.
It's all, they're already brought on.
Please, please.
Yes.
In the cross appeal, we also implemented the
Them
LRs
also.
of the Ashoka.
8750.
My lord, even as per charge sheet also, my lord, 59 years.
That I understood. I will address all your arguments, Mr. Vijay Kumar. What was awarded by the court?
2,64,000.
How much?
2,64,000.
Two lakh 64. Please come. Agreed with the award passed in MVC number 131 of 2013 dated 7 February 2017. The insurance company is before this court. The claimants have filed the cross objection number so and so. The facts of the case are the deceased was proceeding on 19/3/2012 on his motorcycle towards Bangarpet and at 7 p.m. when his motorcycle was proceeding on the road in between Chikkasala/Dimba village gate. It was proceeding on the left side of the road slowly and by observing all traffic routes, and at that time, driver of the RTC bus drove it in an opposite direction with high speed and in a rash and negligent manner and dashed the motorcycle, and due to the impact, he sustained fatal injuries and succumbed to the same. The police have registered a case against the driver of the APSRTC bus and he was charge sheeted. It is a case of the claimants that the claimants are the son who is 28 years old and the daughter who is aged about
30, their age is not shown, my lord. In the cast title.
and the daughter. It is a case that they're depending upon the father.
Kalavati is 24 years, sir.
How much?
Kalavati is 24 years,
The
sir.
daughter 24 years.
And
Case that they're depending upon the
second petitioner,
father.
the age is not shown.
Father is the father is earning 25,000 per month. The court, the tribunal has held that the accident had taken place because of the rash and negligent driving of the driver of the APSRTC bus. While coming to the said conclusion, the court has observed that as per the evidence of the driver before the as per his evidence, what has happened? Well, as per his evidence, he was driving the bus. Accident had taken place. A crime is registered. Charge sheet is filed. The pending consideration. And he has not filed separate complaint either to the police or to the court, alleging that the accident took place due to rash and negligent act of the rider of the TVS, negligent act of the deceased. The court, basing on this, has come to the conclusion that the accident had taken place because of the rash and negligent driving of the driver of the bus. When it comes to the compensation, the age was taken as 48 and the income was taken at 4,500 and granted the compensation. When counsel appearing for the insurance, the APSRTC submits that the tribunal has erred in fixing the liability on the driver of the bus when when the deceased has come in the wrong way and entered into the highway and because of his negligence, the accident had taken place. This aspect was not considered by the court. It is submitted that as per the Aadhaar card and other documents, charge sheet, the age is shown as
59 years.
59 years, but the court has taken 48 years as the age. It is submitted that even according to the claimants, the age of the father is
48 years.
48. According to the age is 48 years. Then how is it useful to you? If it is 48, court has taken 48.
59. As per the charge sheet,
No,
as
I
per
was
the
saying
voters
that even
list,
according to
as
them,
per
some-
the even Aadhaar card, my lord, they have shown wrong, my lord.
It is submitted that the
That
claimants
cannot
have
be
shown the age of the father.
As per the statement given to the
Further
police,
submitted that the this
Police
MFA
have
is filed
recorded
in the year
59 years.
2017. Having received the amount, the respondents cannot file the claim, the cross objections in the year 2022. That there is barred by the barred by limitation and that cannot be entertained. Next para. When counsel appearing for the respondent claimants submits that the son is no more and his LRs are already brought on record. The LRs are already brought on record. Both the son and the daughter were depending upon the father. It is submitted that this accident has taken in the year 2012. Is their case that is earning 25,000? Court had taken 4,500. Court ought to have taken at least 7,000 as the income. It is submitted that when the postmortem report reveals that the age of the deceased is 45 years, the court ought to have taken the same, ought to have taken the said age into consideration. It is submitted that on all counts, the compensation that is awarded by the tribunal is not just and reasonable. It is submitted that when it comes to the negligence on the part of the rider, the respondent insurance company has not adduced any evidence. And the evidence on record clearly shows, that is the police records, that the negligence is on the part of the driver. It is submitted that there are no grounds to interfere as far as the negligence aspect is concerned. Next part. Having heard the counsels on either side, produce the material on record. First, coming to the aspect of negligence, as rightly argued with the learned counsel appearing for the respondent, except the grounds that are taken, no evidence is adduced by the insurance, the APSRTC in this regard. The police records are against the appellant, the driver of the appellant. The appellant, in those circumstances, there is no other material for this court to come to the conclusion that the deceased was negligent. Hence, this court finds no reasons to interfere with the order, with the award passed by the tribunal on that aspect. Coming to the income, according to the learned counsel for the APSRTC, the age should have been taken at 59 years. In these kind of discrepancies, when in respect of the illiterate persons, when the ages are shown, different ages are shown on different documents. When in a case of death, the court will necessarily look at the postmortem report. In the postmortem report, the age of the deceased is shown as 45 years. Hence, this court is inclined to take the same as 45 years. Coming to the income, this accident had taken place in the year 2012. According to the court, there is no evidence that the deceased is earning 25,000. The court ought to have taken at least 7,000 as income. If the income is taken at 7,000, as he is aged 45 years, 25% future prospects would come to 1,750. That is 8,750. As there are two claimants, 1/3 is deducted. 1/3 comes 2,916.
My lord, they are married, my lord. 1/3 to be taken as a dependency, 2/3 to be deducted. Because no wife and they are the major married children.
It comes to 5,834 into 12 and the multiplier of 14. It comes to 9,80,112. Towards consortium, 48 into 2, 96,000. Funeral expenses, 36,000. In the light of the law, later on, make a law also so and so. The legal expenses, 10,000. Altogether, the claimant is entitled for an amount of rupees 11,22,000. Accordingly, the appeal of the insurance company is dismissed. The cross objection is allowed by enhancing the compensation from 2,64,000 to 11,22,000. The amount in deposit shall be forthwith transferred to the tribunal. The apportionment of the compensation shall be as per the award passed by the tribunal, and whatever is the compensation that is awarded to the son, it will be that should be apportioned towards the LRs.
Please.
Much obliged.
2/3 to be taken as personal expenses. Amount in deposit may be transferred to the.
That also is it. Hello. Yes.
Serial number 6. A. Pradeep. For appellant.
Appearing for the appellant.
Here for respondent number 3.
Appear for the claimant respondent and the cross objectors. Questioning the liability on the ground that, my lord.
No, both 6 and 6.1 filed by you.
No, my lords. B. Pramod.
Pramod.
B. Pramod. By the claimants, my lords.
So you're on
Initially
what point?
Initially same, initially same, name is changed.
Take this, the Anita. So you're on what point?
On the ground that, my lord, the deceased said to be coolie working under the borewell lorry. When the work is going in the Rajapa's land, the pipe of the borewell lorry fall on the coolie, my lordship. And he sustained head injury and succumbed to the same. There is no rash and negligent driving of the driver of the lorry, my lord. They have to take precautionary measures while using the borewell.
So usage of the vehicle.
The rigwell bore lorry, who is, my lord, is the digging the
No,
in
that's
the land, my
true.
lord.
Usage of the vehicle is sufficient.
Usage of the vehicle is there, my lord, but
Where is the negligence on his part?
no negligence of the
On the
driver.
part of the claimant?
Claimant, but they have not taken precautionary measures, my lord, while digging that borewell, my lord. In
What is the evidence in that regard?
evidence, my lord, we have not laid any evidence, my lord. The owner of the vehicle who has not admitted the relationship, my lord, is resident of Andhra Pradesh, and the deceased was resident of Chitradurga. And he has given evidence before the court, my lord, he has not accepted the relationship.
Criminal case is registered?
Yes, my lord.
Criminal case is registered?
Yes, my lord. Yes, my lord.
With the same facts?
Same fact, my lord, but against the owner of the lorry and my lord, that manager who was digging that lorry, his manager, my lord, against this, not driver of the insured lorry. There is no 217 in it. There is no 217. Rash and negligent driving has not been.
No, that's not necessary in all the cases, isn't it? No, vehicle is insured, and by usage of that said vehicle, it's a bore.
Yes, my lord. If there is, my lord, there is a relationship between the owner and the.
It's not under Workman Compensation Act.
My lord, they are saying that he is working under the owner of the lorry. The lorry owner who has been examined before the court, and we are saying that, my lord, is might.
Say on that.
Lord, Section 167 of the MV Act, my lord, provides.
Not about that, about the relationship. Why were you there? According to you, you are working.
I am working, my lord.
The owner says you are not working with him.
Lord, he doesn't deny anything, my lord. He says that accident has not happened. If there is insurance is there, company has to pay the amount. That's what it's.
But he doesn't deny the relationship.
He doesn't nowhere says specifically.
Huh?
He doesn't admit and he doesn't delay.
Then it is deemed to be admitted. And then come to the compensation
Next
part.
quantum is concerned, my lord.
Come to that.
Please, my lord. The deceased was aged about 60 years, my lord.
What is the age?
60 years, my lord. The question of adding 15% future prospect does not arise.
For how much, which year is the accident?
Accident is 2014, my lord, 8,500 instead of 6,500, my lord. 6,500 as considered.
No, 2014 it is 8,500.
Yes, 8,500.
Quota taken?
6,500.
So we will take 8,500. So no future prospects for the age of 60.
Yes, ma'am.
So 8,500. And how many are the dependents?
Wife and son.
Huh?
Wife and son.
1/3.
Yes, ma'am. Please.
It comes to 2,833.
6,12,000.
5,667 into, what is the multiplier?
9 million.
It comes to 612,036. 48 into 2, it comes to 96,000. 3610.
$7,44,000.
7,54,000.
10,000.
10,000. Please come.
Well, interest 8%.
How much is awarded?
8,53,000.
8 lakh?
8,53,000. 164 million.
Lord, under few heads, there has to be some modification.
Huh?
Some heads.
Conventionally,
some heads, they have given higher compensation. That has to be
that is
modified.
So what I have done is 6,12,000 loss of dependency, 96 consortium, 36 funeral expenses, 10,000 legal expenses. It comes to 7,54,036. Agreed by the.
Interest 8%, that may be 6%.
6%. Agreed with the award passed in MVC number 5552 of 2014 by so and so, dated 27 September 2016. Both the claimant as well as the insurance company are before this court. The insurance company's appeal is MFA number 3664 of 2017. And the claimant's appeal, not appeal, the insurance company has filed MFA number 3664 of 2017. And the claimants have filed MFA crop 5 of 2019. The land council appearing for the appellant insurance company submits that there is no rash and negligent driving on the part of the driver of the borewell lorry. And in that case, when there is no negligence, the insurance company is not liable to pay the compensation. It is submitted that the owner of the vehicle does not accept the relationship with the deceased. It is submitted that the compensation that is awarded by the tribunal is on the higher side. For an age of 60 years, yeah, the future prospects are taken at
15%.
future prospects are taken at 15%. Even under the other conventional heads also, the amount that is awarded by the tribunal is on the higher side. Next para. When counsel appearing for the respondent claimant submits that the tribunal has rightly considered the aspect of negligence. It is submitted that the use of vehicle itself is sufficient. Further, the owner of the vehicle has never denied the relationship. He only stated that if, as a vehicle is involved, is insured with the respondent insurance, with the appellant insurance company, the insurance company is liable to pay the compensation. When it comes to on what ground you file a cross objection? What enhancement you want?
Income, that's the income part, my lords.
It is submitted that the court ought to have taken the income at 8,500 as the accident has taken place in the year 2014, but the court had taken 6,500. Hence, the compensation needs to be enhanced. Having heard the counsels on either side, perusal material non record. First, coming to the submission of the land counsel for the appellate with regard to the negligence and negligence is concerned for claiming the compensation under the provisions of the Act. Involvement of the vehicle is sufficient in the nature of this, where the vehicle is a borewell, which is for the used borewell lorry, which is used for digging the borewell. Because of while digging the same, as it fell on the deceased, he died in those circumstances. This court of the view that as a vehicle is insured with the insurance company is liable to pay the compensation. Then coming to the aspect of compensation, as the accident had taken place in the year 2014, this court is taking the income at 8,500. The deceased is aged about 60 years. He is not entitled for future prospects. As there are two dependents,
Please.
1/3 has to be deducted. That is 2,833. Then the contribution to the family is 5,667 into 12 into what is that? You said the multiplier?
Nine.
It comes to 6,12,036 towards consortium. 48 into 2, 96,000. Funeral expenses 36,000. In the light of the law laid down in Mekala versus so and so, 10,000 towards legal expenses. Altogether, the claimant is entitled for 7,54,036. In the submissions of the appellant, you write that the compensation, the interest is awarded at 8% instead of 6%. Hence, finally, in the discussion, the amount of the interest that is awarded is 8%. The same is reduced to 6%. Accordingly, the appeal of the insurance company is partly allowed by reducing the compensation from 8,53,164 to 7,54,036, and the appeal and the cross objection filed by the claimant is dismissed.
Question number 7, A.M. Krishnaswamy for appellant. A. Keshava Bhatt.
Number 3, my lord.
Take this. Yes. Where is Mr. Krishnaswamy? Why there is no representation for dismissal on next Friday? Yes, 8.
Question number 8. Question number 8, Nagaraj Hegde.
Yes.
My appeal is on quantum, my lord.
There are 2 appeals. Yes, on what ground you are?
The driver did not have driving license. He was a driver and also a workman. He did not have driving license.
It's a workman compensation.
Yes.
Lord, I'm relying upon 2 judgments of the Honorable Apex Court and as well as.
The law on that.
Milord, the judgment of the Supreme Court in Veliram, it says that I'll just read out para number 23, that would be relevant. When we turn to the facts of the present case, there is almost an identical situation where the appellant has permitted to let the first respondent driver to drive the truck with an expired license for almost 3 years. It clearly a case of lack of reasonable care to see the employee gets his daily license renewed. Further, if the original license is verified, certainly the employer would know
the license expires. So having regard to this, he should have taken a reasonable care.
No, under the Workmen Compensation Act, under the MB Act, there is a distinction.
Lord, my humble submission would be, my lord, he was an employee that is not in dispute, my lord. As on the date of accident, my lord, he was an employee of respondent number 1. That is not in dispute, my lord. And in the written statement, there is no pleading insofar as non-possessing the license by the driver of
You
the,
can show,
please.
no, it's not about the pleading. If you say that you are having a driving license, please place before.
But that is
Sir,
not in
apart
dispute
from
at
that-
all, my lord. If they are asking, my lord, that should have been produced.
Now you can,
No, ma'am.
if you have.
Lord,
I'll read the finding
no.
of the tribunal at para number, page number 9. The father of the deceased was examined before the court. Your Lordship may kindly see the observation. Exhibit R1, the police have registered a case against the deceased Ramesh Basappa under section 3(1) read with 181 of the Motor Vehicles Act. The question is whether the production of the charge sheet is sufficient to hold that the deceased was holding the driving license. PW1 is the father of the deceased, has clearly stated in the cross-examination that his son had driving license and he can produce it if traced. He has not produced it. A specific question was posed in the cross-examination. And further,
Is it now?
Lord,
my lord, last time the matter
this
was
court
heard.
has directed me to produce. Lord, I did not contact, my lord.
If you don't have the
Lord,
license.
that's why, my lord, kindly come to, my lord, the judgment which is referred by my late friend, my lord, in Beliram's case, my lord, paragraph number 8, my lord. That has been given, my lord, it is there. Why the, my lord, court has passed?
Because
such
I
a-
have also taken a view on this. I have also passed earlier orders. As far as the workman compensation is concerned, the not having the driving license, that cannot be equated with that of
Correct, my lord.
motor vehicles.
My lord, the Honorable Apex Court has observed why, my lord, the order of pay and recovery is not
This
passed.
is judgment of Gurmail Singh.
Beliram judgment, my lord, which my learned
There
friend
is
is relying
some
upon.
Gurmail Singh judgment is here.
That is my judgment. I am relying upon judgment. The pay and recovery,
What are you retail,
pay and recovery order has been passed.
will not apply in
That has been passed by the Supreme Honorable Apex Court, my lord. That is what, my lord, I am relying upon that judgment, my lord. Before that, my lord, I'll read, my lord, this judgment, Beliram judgment, my lord, paragraph number 8, my lord. Paragraph number 8. I may permitted to read, my lord. Why, my lord,
What is this Justice Sanjay Gowda's judgment?
that is what, my lord, pay and recovery order has been passed. In that judgment also, I am relying upon it.
That's what I'm saying. It shouldn't be contrary to the order of the Supreme Court.
Before that, my lord, I want to bring it to the notice of this honorable court, my lord. Paragraph number 8 of the very same judgment, my lord. Bailey Ram's judgment, my lord. Honorable Apex Court has held. Observe.
Yes, paragraph,
Paragraph number 8, my lord.
read.
578.
Hmm.
We have heard the learned counsel for the parties and on a,
Paragraph number 8 reads as the only question which has to be debated. There is a copy of, it's a copy of the judgment, not reported somewhere.
It is reported.
SCC 2022.
So
I have.
what is placed before the
Yes.
court is that?
It is
How
the
what-
downloaded
how it
copy.
starts?
We have heard the learned counsel for the parties and
That is
on a
9,
query.
para number 9.
We have heard, yes.
Yes, my lord. We have heard the learned counsel for the parties and on a query being raised whether there is a view taken on the question as to what would be the consequence of valid driving license having expired. Both the learned counsel for the appellant and the learned counsel for the respondent number 2 insurance company stated that there was no direct view on this point. We even posed a question for any judicial view of the high courts in this behalf, but the answer to the same was also in the negative. We reserved the orders because we wanted to satisfy ourselves over this aspect. We have not seen able to trace out any judgment of this court, but there are judicial pronouncement of the high courts dealing
You
with
can
the
come
same.
straight away to para 13.
Yes, my lord. Therefore, my lord, the honorable apex court.
No, you read it.
Yes, my lord. I'll
Come to para 13.
13, my lord.
The submission thus was that.
Yes, my lord. The submission thus was that appellant as insured had taken the adequate care by verifying the license of the driver first respondent at the time of employment, and the liability could have been mulcted on appellant only if he was aware or had noticed that the license was fake or invalid and still permitted the person to drive. This was stated not to be the factual position in the present case, as the issuance of the license has not been doubted, but rather that it was not subsequently renewed, which was pleaded to be the responsibility of the first respondent. Lord, they also, my Lord, refer the judgments of this honorable court passed in, my Lord, Hemraj's case, my Lord, and in paragraph number 21 in my judgment, my Lord, it may be on 22, my Lord. They have full.
Para 15 is with regard to the liability of the owner of the vehicle.
It starts from, my Lord.
Para 15, we are of the view
We
that
are of the view that once the basic care of verifying the driving license has to be taken by the employer, though the detailed inquiry may not be necessary, the owner of the vehicle would know the validity of the driving license is set out in the license itself. It cannot be said that thereafter he can wash his hands of the responsibility of not checking up whether.
he's a driver.
Yes.
He's a driver.
He's a
inside.
driver.
Now, you are a driver.
Yes.
And you, without a driving license, you're driving the vehicle.
No,
Why
ma'am.
should
In the evidence, we have stated we have the driving license.
produce it?
And madam, my humble submission would be, my Lord, in this case, my Lord, in Beliram's case, my Lord, they have produced the license. They have, and my Lord, they have summoned the owner of the vehicle. In the present case on hand, they have not summoned the owner of the vehicle. They have not examined.
No,
And they
you
have
are-
not asked to produce the license.
That's not the argument.
That is what,
You are the driver, you will have the license with you. Why should the owner be summoned?
Lord,
If it is summoning of owner and all will arise in case of a third party, not in your case.
Lord, Delhi High Court, my Lord, in this regard, my Lord,
I
has.
have also already taken, I've heard this matter earlier and some other this thing. It can't be. No, you are the claimant. Your mistake that you don't have a driving license. For your mistake, why should somebody
Lord,
compensate?
I have
it?
not taken any contention that I do not have the driving
Then
license.
show it. That's a simple answer. You show it, we will consider it. Nothing else.
One effort I will make, Lord.
Yes. Does this matter on next Friday? No further time.
Number 9.
Obliged.
Number 9.
We for respond number 1.
The appellant in this case.
On what ground you are before the court?
He claims to be auto rickshaw driver, makes an attempt to pick up a helmet which had fallen on the roadside while driving the vehicle. It is not an employment injury. It is not an employment injury.
Oh, it's a workman compensation.
Yes. Then, no medical evidence.
No, that has taken place. He was driving the vehicle during his course of employment.
Correct. But no evidence is let in, the employer is not examined, no document is produced with regard to the employment. Then when he was driving the vehicle, makes an attempt to pick up a helmet where fallen.
Let's read the findings.
What?
Let's read the findings.
Yeah, I shall. It is skeptical.
Let's read from paragraph number 19.
Yeah.
Nine. Paragraph 9. Next para, overleaf. It is a case of the petition.
Point number 9. Paragraph 9, points 1 to 3. Whether he is an employer, employment injury or otherwise, how much is the employment. These 2 points will be taken into at one stretch for my consideration in order to avoid repetition of facts as they are interrelated with each other. It is the case of which that he is the employee working under the respondent number 1 as auto driver. That on 3/4/2012 at about 6 p.m. due to capsize of the auto bearing the sustained injuries and permanent disablement. Then he was shifted to hospital where he was admitted as inpatient. After taking treatment, he was discharged from the said hospital. Prior to the hospital accident, he was hale and healthy, and due to the accident, he sustained permanent disability and now unable to do his previous avocation of driving. Though the percentage of disability is not given, but the nature of work requires proper exercise of both legs in this regard. It is not an injury to the leg. I'll show that also. Other than driving the petitioner, he has no avocation. So by the injury sustained by him caused loss of earning. On the other hand, there is no objection filed on behalf of the respondent, but the respondent number 2 has filed objection denying the age, avocation and income of the petitioner. Hence, the petitioner, in order to prove this, has got examined himself as PW1 by reiterating all the ever mentioned in the petition in his affidavit. Further, to prove his age, income and avocation, the driver of driving under the respondent, he had got marked a copy of the FIR, complaint, wound certificate, intimation, accident report as exhibit P1 to P5. On the result of this document, it can be noticed that the age of the petitioner is mentioned as 28. Yes, no contrary evidence is produced by either of the respondents. Further, respondent number 1, even though appeared before this court, did not file the objection or adduce the rebuttal evidence in refuting the allegation of the petitioner that he is not the employee under him. Hence, an adverse inference can be drawn against
Where
the
do you
respondent.
get this, that because he's picking up the helmet, it has
Yes,
happened?
yes.
It only says the auto is capsized, that's why he's,
FIR.
just take the FIR. You please read it and tell the court what it is.
FIR.
So where is it? Where is the cross-examination? Where did you give a?
I shall read
submission to
it
him?
also. I shall read it also. FIR.
No, that's anyway in Kannada, you read.
Only 3-4 lines. I'll read
You
it.
can read.
ಪ್ರಕರಣದ ಸಾರಾಂಶವೇನೆಂದರೆ ದಿನಾಂಕ 3-4-2012 ಬಿದಿಯಾದ ಸಂಜೆ 6 ಗಂಟೆಗೆ ಜಪ್ಪು ಬಪ್ಪಾಲ್ ಬಳಿಯ ಯೂನಿವರ್ಸಲ್ ಟೈರ್ ಶಾಪ್ನ ಎದುರು ನಿಂತಿರುವಾಗ ವೆಲೆನ್ಸಿಯಾ ಕಡೆಯಿಂದ ಕಡೆಗೆ ಆಟೋ ರಿಕ್ಷಾ ನಂಬರ್ ಸೋಂಡು ಅದನ್ನು ಚಾಲಕ ರಾಘವೇಂದ್ರ ಎಂಬುವರು ಸಾರ್ವಜನಿಕ ರಸ್ತೆಯಲ್ಲಿ ದುಡುಕುತನ ಮತ್ತು ನಿರ್ಲಕ್ಷ್ಯತನದಿಂದ ಚಲಾಯಿಸಿಕೊಂಡು ಹೋಗುತ್ತಾ ಯೂನಿವರ್ಸಲ್ ಟೈರ್ ಶಾಪ್ನ ಬಳಿ ರಸ್ತೆಯ ಬದಿಯಲ್ಲಿ ಬಿದ್ದಿದ್ದ ಹೆಲ್ಮೆಟ್ ಅನ್ನು ಹೆಕ್ಕಿ ತೆಗೆದುಕೊಳ್ಳಲು ಹೋದಾಗ ಆಟೋ ರಿಕ್ಷಾ ನಿಯಂತ್ರಣ ತಪ್ಪಿ ರಸ್ತೆಗೆ ಮಗುಚಿ ಬಿದ್ದು ರಿಕ್ಷಾ ಚಾಲಕ ರಾಘವೇಂದ್ರ ರಾವ್ ಅವರ ಹಣೆ ಎಡಬಾಗಿ ಸಾದಾ ಸ್ವರೂಪದ ರಕ್ತಗಾಯ ಉಂಟಾಗಿ ಫಾದರ್ ಮುಲ್ಲರ್ ಆಸ್ಪತ್ರೆಗೆ ಒಳರೋಗಿ ಚಿಕಿತ್ಸೆಯಲ್ಲಾಗಿರುವುದು ಎಂಬಿತ್ಯಾದಿ.
Yes. What do you say?
That is.
It is not the auto driver who has gone to pick it up. It is not the claimant here, Malats, who has
One
gone.
minute, let him say, what is that?
It is not the claimant, Malats, who has gone to pick up the helmet, Malats. It is during that action that the auto lost control and he has capsized it.
Because the helmet was on the road, because of that the auto has auto caps.
It was someone else, it was not the driver who picked it up.
The allegation in the FIR and the contents are that he made an attempt to pick up the helmet which had fallen on the roadside while driving the auto rickshaw in a rash and negligent manner. Consequently, the auto rickshaw capsized and he sustained injuries.
It is not
Is it
possible.
so?
No, that is not possible to do.
That is what is mentioned in the FIR that is produced by them.
The petitioner shall place the translated copy of the 3 lines in the, not the entire one.
Yes.
These 3 lines of the FIR. The 3 lines in the FIR. Only 3 lines are there.
And then the evidence.
Not the entire one. The 3 lines you can tell the court.
Affidavit evidence also is in Kannada.
Is it relevant?
I'll file the, yes, affidavit evidence.
Yes, this is matter after vacation. Not required, even the translated copy don't write. List it after vacation.
Please.
Number 10. Number 10.
Yes.
I am for the appellant, my lord.
You are on what ground?
My lord, only quantum of compensation is required to be enhanced.
You are on what
Insurance
ground?
company appeal is also there, my lord.
On what ground?
It was on negligence, but I'm told that in the other connected matter before Kalburgi bench, it was held against us.
That there was no
But
negligence.
they have produced they gave me the copy. And it is there, it is held that our company appeal is dismissed, my lord.
So we have to look at his appeal for
Yes, ma'am.
enhancement.
For enhancement of company.
It's a case of death or injury.
My
In
lord,
case of death, my lord.
Please come to this is MBC number?
MEC number 4849 of 2016, my lord.
4849 of 2016. Where is the table?
Table, my lord.
Yes.
In this case, the judge, the honorable tribunal has discussed it at page number 24, para 54.
in this case, before that one submission, my lord. In this case, what has happened is the married sisters and married daughters, and one sister had filed who was not married. That unmarried sister was only given the compensation. For them, it's only loss of love and affection was given. And that during the pendency of the claim petition itself, that unmarried sister died. She was, I think, 13-year-old. And her name has been continued. Even have made her as the party in this, in my appeal also. They say that in the limitation application for condonation of delay application, they say that she died during the pendency of the petition itself, claim petition itself. They have not changed that. And moreover, and it is, they say that they made an application under section 152 of CPC before the tribunal. And they have not proceeded with that, my lord. And her name has been continued.
How can it be? How can there be an appeal against in the name of a dead person?
That's what, my lord, it has happened. So they realized it later. They say that in this thing, petition number 4, the name of this connected was not deleted.
This is petition number 4, died on 29/10/2016,
Yes.
as not made as party, and the appellant 1 to 3 are the only legal representatives of deceased so and so.
They're brought on record, my lord. Then only, there only.
So according to you, what should happen? No, she died and the remaining or to whom the compensation is not granted, they are the legal heads.
My lord, may I submit, my lord? For this point, there is a covered decision of the Supreme Court, my lord. Here, I have produced the decision also, 2021 ACJ page 1. The Kirti and others versus Oriental Insurance Company Limited. Death of one petitioner, compensation cannot be reduced because
Not seeking any reduction.
Yes, ma'am.
She is not on that point. She is not on reduction.
Yes, my lord. Here, the decision is also the para number 10 and 11.
Please make your submissions. What is that?
My lord, in this case, she died during the pendency of the petition itself, claim petition itself. They have not brought that.
So that order is passed, even as on the day the award is passed, she is no more.
She is no more. She died in 2016 itself, I'm told.
Then how can that, how this appeal is maintainable?
Yes, my lord. Here, that is why I'm submitting before this honorable court. I have produced the decisions on 27/3/23, my lord. Those
What
decisions.
decision?
Decision of Supreme Court 2021 ACJ page 1, my lord. This is the point involved in this case.
So you please answer the court query.
Yes,
the MBC order is passed on 21st June 2017, granting
Yes, ma'am.
compensation to the unmarried daughter.
Yes,
When
my
did
lord.
the unmarried daughter died?
Died before the judgment, my lord. Before
Then-
the judgment.
then-
And I have filed an application for the even for deletion of that party, petitioner number 4.
Before
And
this
also
court.
I brought the legal representatives on record.
How can it be? How can you?
After that, the judgment has been passed, my lord.
Where do you get that? Please show it from the award that this was brought to the notice of the court. And an award is passed showing her as like so and so is no more and represented by Allahs. Come to that.
that the claim petition itself, my lord, it has been mentioned that the petitioner was poor number deleted on 18/11/2017 itself. Original claim petition, my lord.
How can there be a correction as on the day when the award is passed, she is no more? There cannot be any correction later.
My lord, there is no correction is not required here, my lord. The
Please come
compensation
to,
so far
please
as
come
the
to page 55. Come to page 55.
55. Yes.
Please show from 55. This is the award. This is the award you have placed before the court, which is the executable one.
My lord, and page number only up
Award,
to
whatever is the page, look at the award.
yes, my lord. See that.
It doesn't say that she is no more. She is represented by the other petitioners.
No, my lord, it is a mistake of the tribunal. Before that only we have
Then get it clarified. Please come. Then counsel
Yes,
appearing
madam.
for the insurance company submits that. The fourth respondent in whose favor the compensation is awarded is no more by the date the award is passed. Then counsel for the claimant submits that. They have already filed an application and it was clarified by the court. But the award that is placed before the court is showing the deceased as a life. The petitioner shall get the specific clarification, shall clarify the same, or else the appeal has to be dismissed. Does this matter on 10th of June? Yes.
Cell number 11. Cell number 11, parted.
For the appellant.
Pradeep,
Sorry, my lords, I could not appear before this court, my lord, because my name is spelled wrong. Lord, I was not able to appear before this court in many of the hearings, my lord.
Yes.
Lords have made some directions to the Nimans for 90% disability, my lord. My lords have directed the Nimans to assess his disability. That has not been done, my lord. May I request for a month's time, I will get that done, my lord. I'm not sure about the orders passed by my lord.
What was the order?
Lords have directed the demands, my lord, to
The party to present before the
demands, my lord.
And
Also, there is no
to assessment.
representation. However, considering the evidence of the doctor and also the stand taken by the insurance company, the respondent claimant shall appear before the medical board Nimhans Hospital on 25/9/2025. And the doctors at Nimhans shall assess the disability and send a report to the registry.
Yes, my lord.
They have not.
I have not been, he's not been appeared, my
So when
lord.
he'll go?
Today or tomorrow, my lord. I am in touch with Nimans, my lord. I will send him today or tomorrow. He's here.
This court has passed an order on 11/9/2025 asking the petitioner to appear before the Nimhans on the respondent on 25/9/2025. Then counsel appearing for the respondent submitted as a name is wrongly mentioned in the causeless would not appear. Hence, the respondent is directed to appear before the Nimhans on 16th April. And the doctors at the Nimhans shall assess the disability and send a report to the registry by. So we'll have it after vacation. The report as expeditiously as possible. This is matter on 2nd of June.
This team may also be directed to change my name, my lord.
What is the name of the respondent shall be reflected as?
SHRINIVAS, my lord. It's SRI.
No, it is SHRI.
Because
Right in the paper.
yes, I will do it right.
Shall be reflected as so and so.
Sorry, my lords.
Yes. The parted matter.
Yes.
Not parted, the other matter, passed over matter.
Pass over. Cell number
1990.
Where is,
cell number 19.
My lord, for the respondent bank.
The government advocate all over was here.
First case.
What has happened?
Milord, the survey has been conducted.
As per the survey, what is
Yes,
it?
Milord.
Milord, there is an abut of 80 square meters, Milord, in the mortgage land.
Hmm.
Now, Milord, that
Only
we will.
little marginal overlapping is there. That is a sheet. The house is comes within my survey number. That is the.
And whatever is there, that has to
That
be
we will
removed.
remove it. Let them remove it, Milord. No problem.
Where is the report?
Let the report.
Where is the AGA?
I have a copy.
Please pass on. This is serial number?
19.
In 19.1 also we are seeking.
That are two writ petitions.
Two writ petitions. That is, one is survey number 45/5 and another is 45/7.
No, the survey is in respect of?
45/5 it has been conducted, but the survey, Milord, the sketch depicts that it is not, no way connected with 45/7. Your last.
What do you say? No, what we will do is,
No,
1 minute. Now, what is submitting about this excess 80, whatever, so that is in respect of which writ petition?
Milord, the first, that is with
19,
regard
my
to 15105.
Then we will dispose of this first.
Yes.
The writ petition is filed seeking the following prayer. The grievance of the petitioner is under the guise of the secured asset. The respondent bank is trying to take possession of the petitioner's property. Hence, this court has passed an order on
But 18.3.
No, 1 minute. When is the stay granted?
Data.
Yes. Stay is only status quo, Milord. Status quo.
Where is that, whatever the order? This court on 11/12/2025 has passed an order of status quo. Thereafter, the respondents have entered appearance, and after hearing both the parties, this court has passed an order on on 18/3/2026. Pursuant to the order passed by this court on 18/3/2026, the survey was conducted and the survey is, the survey report is placed before this court. As per the same, the petitioner's survey number is
45/5.
45/5.
45/5.
45/5. 45/5. And what is the report?
The report is.
Milord, mortgage property is 45/3.
Mortgage property is 45/3.
3. Correct.
Milord, in 45/3, Milord.
Has encroached an extent of
40 meters, square
80
meters.
40 square meters.
Milord, that is wrong. Your Lordship may kindly see, Milord, the report, point number 4 and point number 5, Milord. Portion of the building
Portion of the
indicated in the
building,
color.
portion of the petitioner's building falls in survey number 45/3, which is a mortgage land, to an extent of 40 square meters.
And Milord, brown of, next
The
is
portion
Milord.
of the building porch indicated in the map measuring for 40 square meters falls in survey number 45/3. That is 40 plus 40, 80.
80, yes, Milord.
80.
The learned counsel appearing for the petitioner does not dispute the same. In that view of the matter, the petitioner shall remove the encroachment as indicated in the survey report within
ಒಂದಾಯ್ತು ಸರ್, ಇನ್ನೊಂದು ಆರ್ಗ್ಯುಮೆಂಟ್
what he says he will not remove.
No, what he says is I have to cut down the house itself.
But what to do? How can you construct in somebody else's land? Or else it has to be removed. They will remove it if he doesn't remove.
But the removal is only a 14-year order. That order is passed now.
No, whatever now, either you have to do it on your side, on your own, or as per this, there is an encroachment.
No, I
And they
understand.
can't lose their land.
Correct, correct. I understand. Whatever the mortgage property, it's overlapping. That I cannot have a benefit of that. Encroach is encroach.
And the whole purpose of this is that if there is encroachment, it has to be removed. The petition
May I
shall
request me
remove the
ultimately-
encroachment within 4 weeks.
Please, ma'am.
4 weeks from the date of receipt of the copy of the order. Or else the respondent bank is at liberty to take appropriate steps
At the
in
expenses
accordance
of the
with law
petitioner.
in the light of the admitted survey report dated 7/4/2026.
Please, ma'am.
Accordingly,
At the expenses of the petitioner.
at the expenses of the petitioner, accordingly, the writ petition is disposed of. Yes, what about the second one?
That if I make the full payment, the third respondent, if the third respondent makes a full payment, that may be the demolition may be waived off if he is paid. If he pays
Who pays
the mortgagor,
The borrower.
borrower.
Then why will he do it? He doesn't have anything. If payment is paid, why will we do
My
it?
lord, within the time stipulated, my lord, but my lord, that cannot go up to 4 weeks. Now, my lord, we have already lost 2 years because of the status quo order.
That goes without any say. The court need not mention because the original borrower
Let
is
them
not
pay it,
here.
my lord, no problem.
Yes, that's for the bank. Yes. Next, what about the second one?
Second
A
matter.
report is in this.
Report
right?
is
A
not
report is
obtained.
placed by the AGA before this court. Yes.
Report is not obtained. At the last occasion, I mentioned your lordships, it is also covers 45/7. No report is there.
No,
But 1 second, brother.
Yes.
No, we will take
Now
the second
ಮಾತಾಡ್ಬೋದು.
petition now. WP number 1347.
Yes. That is
134. No, we'll see that.
That is 45/7.
No, let's see. What about this?
In the sketch itself, your lordship may kindly
Take
have a
the
look at,
sketch again.
there is no interlinking at all. In the sketch itself, kindly have a look at the sketch now, your lordships have
Now,
perused.
according to you, what is the land?
45/7.
Let's see.
Kindly have a look at the sketch itself. It is separately is there. 45/3 millet, it comes in upper side.
45.
No connection at all.
/7.
No connection at all, according to the survey itself.
What is your land? Only 45/3.
Yes, only.
Yes, Mr. Counsel.
My lord, your lordship may kindly come to page number 55 of the said writ
No,
petition.
I am
my lord.
looking at this map.
My lord, I'll just show, my lord, what are the properties which has been mortgaged by the borrower, my lord, in favor of the bank.
Page number.
Page number 55, my lord, of the writ
No, he
petition.
is a borrower now in this case.
No, my lord, he is not the borrower.
No, it's only about the overlapping, this also.
No, my lord, 45/7 is not mortgaged to us. We are not taking possession of the said land. My lord, but 45/6, my lord, which is above the 45/7. That has been mortgaged to us.
Correct.
That we have taken the possession.
Now,
45/7 we have not taken.
45/7, you are not taking.
We have not taken.
As per the sketch, is there any overlapping?
No,
of-
no, my lord. There is no property also. There
So
is
we will
no,
allow their writ petition.
there is no property also on
Yes.
that land.
The writ petition is filed. Seeking the following prayer. Land Council. The brief facts of the case are that the petition is an absolute owner of the immobile property bearing survey number 45/7, old number 45/3, measuring 3 guntas, situated at Hellahalle village, Kasaba Hopi, Hassan Taluk, which is purchased by way of a registered sale deed dated 4/12/2006. The petitioner's husband has availed the loan from the bank and he has mortgaged the properties in survey number 445/4, measuring 20 guntas, 45/3, measuring 15 guntas, and 36/2, it's all survey numbers, right, survey number. 36/2, measuring 3 acres, 36 guntas, and survey number 15, measuring 22 guntas, and survey number 33, measuring 2 acres, 32 guntas, and survey number 45/6, measuring 23 guntas. Due to the default in payment of the amounts, the respondents have initiated the proceedings under the Surveyors Act and under section 14 of the Act. An order was passed by the magistrate on 17/3. Order was passed, and pursuant to the order, the respondent number 1 and 2 have taken possession of the properties relating to the petitioner's husband on 17/3/2025. It is a case that in the guise of taking possession of the mortgaged properties, they have also interfering with the properties which are owned by the petitioner. It is stated that the property that is 45/7 is a distinct property and it is not mortgaged. And even as per the survey that is conducted, the said property has nothing to do with the mortgaged property, which is an independent property. It is a case that the respondents are interfering with the petitioner's land. Land counsel appearing for the respondent bank submits that as far as the 45/7 is concerned, it is not a mortgaged property.
And we
the
have not taken.
bank is not interfering with the same. In view of the submissions made by the respondent bank, the writ petition is disposed of. In the light of the submission, the writ petition is disposed of, that the respondent bank is not interfering with the same.
Please, ma'am.
Serial number 1, passed over matter.
Bill number 1. Appeal from respondent number 3.
My lords, the position of law in this case is, my lords, the reason is the child has been adopted by both the parents, that is the petitioner as well as the second respondent.
Petitioner is a father or mother?
Mother, petitioner is the mother. Now what happens is, my lords, in 2019, the father and the mother both initiate custody petitions. Thereafter, my lords, what happens
Whom
is,
the son is now?
the daughter is, it's a minor daughter, adopted daughter. The daughter is with the petitioner, with the mother. By virtue of this honorable court's interim order, wherein this honorable court stated, passed an order directing not to take the child away from the minor. But my lord, the position of law is that section 56, subclause 3 of the Juvenile Justice Act is not applicable. It clearly states the children who have been adopted.
What is the order impugned in this?
The order impugned is, my lords, one fine day, the father goes and files a child welfare committee complaint, and the child welfare committee summon the mother, and they tell her, they state that no,
Let's see the order.
Please, Annex Sharia, my lords.
Page number.
Page number 19, my lords. Apologies, 29, my lords. Typed copy. This is the notice that I received, my lords. The moment I received the notice, my lords, I challenged I've challenged the very notice.
You
Before
didn't
this,
even go to them to tell them. that
I was there, my lords. I have appeared there. When I appeared there, my lords, the way.
What does it say? So and so.
My lords, what it says is you are hereby directed to appear in respect of the minor child called Anvita, as the father has filed a complaint. Now, my lords, what happens is when I go, the reason why I moved this matter at that point of time, my lords, this matter was moved in 2021 for 230, is because when I go there, they say you are an unfit mother. We cannot give you the custody of the child because the father has alleged.
No.
No, I object to that extent. There is no finding to that extent. It's only only to appear.
No.
Is there an order also?
When the matters are pending before the competent civil court,
yes,
whatever is the relief you have to seek,
please,
you have to seek from the competent court. Why should you go before the committee? That is not permissible. Because your rights, it is not that independently you are going. You are already you are before the competent court, which will comprehensively decide about the rights of the parties. You can't go before the committee. What is the judgment?
My lords, I shall place the judgment of this honorable court, my lords, Nidhi Luharuwalla's judgment, wherein this honorable court is a reported judgment, my lords. Maybe it might be permitted to place it on records. Third. Give a copy to them. My lords may in fact come to my lords page number 17 in the judgment, in the compilation that I produced before lordships. Page number 17, our High Court judgment, my lord, which is also a report judgment, which says the committee cannot be permitted to usurp the jurisdiction of the competent court exercising powers under the provisions of Guardians Act. Admittedly, the proceeding under the Guardians Act is pending where the issues with regard to the custody of the minor is pending adjudication. In the instant case, the committee, on the basis of the communication sent by the child to the committee, has taken the custody away from the, has taken the custody from the petitioner and has handed over the custody of the child to respond number 3. Under the provisions of Guardians Act, the court is empowered to make an order under section 7 of the aforesaid act. The said jurisdiction conferred by law cannot be taken away by the committee, which is a statutory body. In the fact situation of the case, even if the committee was of the opinion that the child was in need of care and protection, it ought to have referred the matter for consideration before family.
This is Child Juvenile Justice Board or a Child Welfare Board?
Pardon me, minutes.
This is a Child Welfare Board.
No, this is the High Court. This
Board is
honorable court.
constituted under the Juvenile Justice Act only.
Please.
Kindly see Juvenile Justice Act.
My contention is, apart from this judgment, is Juvenile Justice Act, the child in the
No,
present case.
Let's read, look
Please.
at the provisions.
Plus, I am referring to
Constituted under
56.
which provision?
Kindly see page number, section 27, chapter 5,
Child Welfare Committee.
Child Welfare Committee. Like to say that the procedure adopted by this, the Child Welfare Committee to the facts and circumstances to defend that is not maintainable. And
That's why
that is the
that's why I want to look
bottom.
at the
But
provision.
only to say that they have challenged only the notice.
Let's see. Child Welfare Committees. Let's
Committee.
understand why they are constituted. Functions and responsibilities
Section
of the
30.
committee is at
Yes, section 30.
Yes, let's read it.
Taking the functions and responsibilities of the committee shall include taking cognizance of and receiving the children produced before it, conducting inquiry on all issues related to and affecting safety and well-being of the child under this act, directing the child welfare officers or probation officers or district child protection unit or non-government organization to conduct social investigation and submit a report before the committee, conducting inquiry.
All this will come into play when nothing is pending before any.
That I agree.
Section
Proportion of
2D.
law, my lord, is
Pilot section 2D defines as to what defines as to child in need of care and protection. My lord,
2D, let's see.
Section 2D.
Hmm.
Child in need of care and protection, and mentions the categories of the children that are stated to be a child in need of care and protection, which includes Roman number 1, who is found without any home or settled place or abode and without any ostensible means of subsistence. Roman number 2, who has a parent or a guardian and such parent or a guardian unfit or incapacitated to exercise.
come to 5.
2
Section 2
define is a definition.
definition.
Please, that's what.
The relevant, my lord, maybe 5, 2, 5, 2, 14, 5,
2, 14, 5.
2, 14, 5.
Hmm.
Who has a parent or a guardian,
Child in need of care
such
and
parent,
protection means
guardian is found to be unfit or incapacitated by the committee or by the board.
who is found without any home, who is found working in contravention, who resides with a person, is injured, exploited, who is mentally ill or mentally or physically challenged or suffering from, who has a parent or guardian, and such parent or guardian is found to be unfit or incapacitated by the committee on the board. Now, all this is within the realm of the.
Yes.
Please come.
But at 56.3 also, my major contention is
56.
56.3, section 56.3, adoption. My lords, 56(3) says
There is a
clear,
question of adoption here.
the child is an adopted child. That is the reason.
Oh, it's not a, you're not the natural parent.
No, no, no. Child is an adopted child. Page number 63 of my writ
Both of
petition.
you have adopted.
Yes, both of us have, both of the parties have
What
adopted
is
the
the age
child.
of the child?
Child is as of now 13 years, my lords, but my lords may see 56(3). The reason why I draw your attention, the lordship's attention to 56(3) is nothing in this act shall apply to the adoption of children made under the provisions of Hindu Adoption and Maintenance Act. Page number 63 of my writ petition is the adoption deed, my lords.
Please
That
start.
basis, my lords.
The present writ petition is filed, seeking the following prayer. The facts of the case are the petitioner, you're divorced?
No, my lords, the divorce proceedings are still going on.
The-
The father's petition for custody has been dismissed for non-prosecution. My custody petition is still pending. I've stated the numbers, my lords.
There is a cost item.
Page number 8,
The
7 and 8.
petitioner and the third respondent of the wife and husband. In view of the differences between the parties, they have filed MC number 3274 of 2019 seeking divorce. The divorce on the ground of cruelty, which is pending with the first additional principal family judge, Bangalore. Both of them have adopted the child by way of an adoption deed dated
My lords, page number 63, once.
page
I just. Adoption deed dated 29 December 2014, my lords.
29 December 2014. In the light of these disputes, both the parties have filed the custody petition, the GNWC before the family court. It is the case of the petitioner that the GNWC filed a petition filed by the respondent seeking custody is dismissed.
For non-prosecution, my lords, he is
This is
not.
for non-prosecution
Yes.
and it is not restored so far.
No, not.
Whereas the petition that is filed by the petitioner mother is pending consideration. While this being so, the petitioner has received a impugned notice to appear before the Child Welfare Committee dated
My lords, please, my lords. My lords, I received a notice.
notice is dated.
On, my lords, the notice dated is 4/11/2021, my lords.
4/11/2021. Questioning the same, the petitioner has come before this court. When counsel appearing for the petitioner submits that the Child Welfare Committee has no jurisdiction to issue a show cause notice to the petitioner to appear. It is submitted that the dispute with regard to the custody is pending before the competent civil court in the
Family
pending
court, my lords. Family court,
before the
GNWC.
family court in the pending GNWC case. When the matter is seized off by the court, when the rights can be decided only by a court, but only by the family court, which is hearing the GNWC matter, the Child Welfare Committee has no jurisdiction to issue such notice. It is submitted that if the petitioner, if the respondent further, the third respondent further has any apprehension with regard to the safety and otherwise of the child, the same can be brought to the notice of the family court where the GNWC petition is pending, as well as the MC petition that is pending. It is submitted that the Child Welfare Committee has no jurisdiction. He has relied on the judgment of the coordinate bench of this court in case of, what is that?
Nihi Luharuwalla versus State of Karnataka.
Page number? You
Correct,
passed
sir.
it
17,
on now.
the relevant portion is at 17, my lords. Page number 13, the judgment starts from, my lords. Nidhi Luharuwalla was the state of Karnataka, 7th February 2019.
Yes, yes. It relied on the judgment of the coordinate bench of this court in, was this in Seva Chakka Samajam?
No, my lords. Page number 13, my lords.
Mrs. Nidhi Lahulwala was the state of Karnataka, arising out of writ petition number 1372 of 2019. He has relied on paragraph number
36.
136. Now, what is that paragraph number?
There might be an error, my lords, but paragraph number is, my lords.
It must be paragraph number 10.
Please. This is 11, my lords.
Huh?
This will be 11.
11 paragraph. Look at here, this part. Extract the entire paragraph. And he has also relied on section
56(3).
53.
56 subclause 3.
56 subclause 3.
56, my lords.
Subclause 3, where the committee has no jurisdiction when particularly with regard to the cases where adoption has been where the child is adopted under the child is in the Hindu Adoption and Maintenance Act. It is submitted that on all counts the Child Welfare Committee has no jurisdiction. Next, and counsel appearing for the third respondent submits that considering the issues that are faced by the child and in the interest of the child, a complaint is given to the Child Welfare Committee and the notice is issued. The petitioner ought to have appeared before the committee and he cannot come before this court. Learned AG appearing on behalf of the which respondent 1 and 2 submits that the petitioner, when the show cause notice is given, if the Child Welfare Committee has no jurisdiction, the same could have been stated before the committee by appearing before the same. It is submitted that the writ petition is a premature writ petition.
My lords, I filed my objections to the complaint.
It's a premature writ petition and the same is not maintainable. In response to that, the counsel for the respondent petitioner submits that in fact he has appeared and filed his objections.
Page 70 to 75.
Submitted that the initiation of proceedings itself or entertaining the proceedings itself is a pure abuse of process and contrary to the provisions of the Juvenile Justice Act as well the act which for having got the counsels on either side there is a material on record. Admittedly, in view of the child is adopted by the petitioner and the third respondent, both the disputes, matrimonial dispute, that's MC is pending, as well the petition that is filed seeking custody of the child is also pending before the family court. The respondent, if at all, has any grievance with regard to any of the conduct of the petitioner, he would have brought it to the notice of the court in the pending GNWC. Instead of doing so, he has gone before the Child Welfare Committee. The Child Welfare Committee is constituted as per under the Juvenile Justice Care and Protection of Children within brackets Act 2015. Section 27 of the Juvenile Justice Act deals with the constitution of the Child Welfare Committee, and Section 30 deals with the functions and responsibilities of the committee. The dispute that arose between the parties would not fall under any of the functions and responsibilities of the committee as per Section 30 of the Juvenile Justice Act. Then coming to Section 56.
Subclause 3, minutes, 56 subclause 3.
Section 56 of the Act deals with adoption, and particularly Section 1563 states nothing in this Act shall apply to the adoption of children made under the provisions of the Hindu Adoption and Maintenance Act 1956. A reading of all these provisions makes it very clear that the notice that is issued by the Which respondent, second or third?
My lord, is the second respondent. One second.
By the second respondent is without any jurisdiction. And the, the second respondent cannot interfere
Second.
with these kind of matters where the dispute is pending before the civil court, before the family court. Accordingly, this court is passing the following order. The writ petition is allowed by setting aside the so-and-so. There is a show cause notice dated so-and-so issued by the second respondent. Number two, the third respondent is at liberty to act any of its rights before the civil court, before the family court, where the TNWC is pending.
Proceedings are quashed.
Huh?
Proceedings would have in its entirety would have to be set aside.
Set aside, show cause notice is set aside, writ petition is allowed.
Great. Oblige. Oblige.
Who that?
Yes.
10:30.
Where is that letter? That memo to withdraw? Where is that? That's what they wanted to withdraw. All the advocate's name, otherwise how will they know? I think you have taken a wrong file. We wanted to withdraw the writ petition. That's why it is given. All the advocate's name.
C. Vinay Swami, Vinay Kumar, C. Vijay Kumar.
Talk to him if he comes, just ask him what it is. Or it's visit after vacation. Yes, next.
Number 3.
For the,
Then number 1. Station B.
there are 3 cases. The second and third are the appeals filed by the insurance company challenging the award. The first one is for enhancement claim filed by the claimant.
Who appears for, where is the advocate Srinivasa KL?
Yes, I am here, ma'am.
Huh?
I represent appellant in the connected insurance.
No, who appears for the insurance company? You
I represent, yes.
Yes, on what ground the insurance company is before the court?
No, as there is a document we adduced before the court that which exhibit P9, it discloses that the accident was occurred and the claimant has sustained injuries while traveling in the while traveling as a passenger in the lorry. Our contention is passenger in the lorry is not covered. Under the policy, we are
according to
not
them, he
liable.
is working in, he is working with the employer, with
Yes,
the lorry.
yes.
Huh?
No, he was a passenger in a lorry.
That is your
Goods vehicle.
contention.
That is my
What is
contention.
their contention?
Their contention is he was sitting, so he was standing by the roadside and the lorry came and hit him and hit
So
the
to
tree
say
and
that
it
he is traveling as a passenger in the lorry, what is the evidence?
evidence. They have, nothing has been produced, that is the
For you
evidence
to
on
produce,
record.
not for them. If that's your case, then you have to produce.
No, they have produced a document, the summary discharge, which discloses, exhibit P9 discloses that he was traveling as a passenger in the lorry.
In the evidence, they say that they are standing on the road.
Yes.
No, forget about the affair. What about the medical document? But that is the crucial aspect. When you, as far as the one who says that he is sitting in the lorry, is it what are the injuries to him? Is he conscious when he went to the hospital? Who took him to the hospital? Hmm. He was also? Hmm. No, who gave this information to the medical officer saying that he was traveling in the vehicle, in the lorry?
Accident occurred on 18/12/2012. This discharge certificate issued by NIMANS discloses court officer idea trial court record.
Please look at the record next week. It's all these matters next week. Thereafter. He has come. What is it? That advocate. I'll take up next week. Date. She will indicate the date. It will come on 24th. 17th already there are so many matters. Yes. What is this? No, ask him. He has come. Call the name of the advocate.
Yes. I'm filing a memo for withdrawal.
Take that.
What is the proposal they are considered, madam? Can it be taken?
It is, a memo is filed stating that the bank has considered the OTS proposal. Hence the petitioner wants to withdraw the writ petition. Accordingly, dismissed as withdrawn. Yes.
Please.
Any signatures? What to do?
Serial number 3, my lord. List number 3, serial number 3. Next week, ma'am.
No, next week there are so many matters. It will come up on 28th.
Serial number 4, not.
No, 24th.
Serial number 4, ma'am. Sorry.
Huh?
Serial number 4 only. It's a case of death, my lord. Next week we'll report the settlement.
Yes, next week.
ಅದು ಆಫ್ಟರ್ ವೆಕೇಶನ್ ನಾನು ಇರೋದಿಲ್ಲ 24ಕ್ಕೆ ಸರ್ ನಾವು ಹೆಂಗೆ ಮೇಡಮ್ ಹೇಳಿದ್ದಾರೆ
Madam Court Officer. Hello, Madam.
ಹೇಳಿ
ಸಿಟಿಗೆ ಇದೆಯಾ ಮಧ್ಯಾಹ್ನ?
ಇಲ್ಲ
ಇಲ್ವಾ? ಸೊ ಆಲ್ಟರ್ನೇ ಮ್ಯಾಟರ್ ಯಾವತ್ತಿಗೆ ಹಾಕ್ತೀರಾ ಮೇಡಮ್?
ಅಂದ್ರೆ 24.
ಥ್ಯಾಂಕ್ ಯು ಮೇಡಮ್.
ಮೇಡಮ್ ಥರ್ಡ್ ಲಿಸ್ಟ್ ಎಲ್ಲ 24 ಮೇಡಮ್?
ಇನ್ನು ಉಳಿದಿದ್ದ ಮ್ಯಾಟರ್ಸ್ ಎಲ್ಲ 24 ಎಕ್ಸೆಪ್ಟ್ ಸೀರಿಯಲ್ ನಂಬರ್ 3.
Okay.
That is on 17/4.